Let's try this again, folks. Let's let's try this again. New stream. Let's try it again. Fingers crossed is right. See if we can get this running here. I don't know what's going on, so it's obviously not my own, not just me. Whoever's using StreamYard clearly saw something happen. Thanks, StreamYard. We appreciate you for interrupting an important day of testimony, you jerks. So give us a second to get it up, get it running. Freaking StreamYard. So obnoxious to me. Yeah, real inconvenient. It really puts a damper on the day when it does that. Let me see if I can see it in YouTube now, or at least see myself. Can you guys see me? You guys can see me, right? Yeah? I'm hoping at least y'all can see me. It's so obnoxious. They don't make it easy, that's for sure. What the frick? All right, you can see me. Okay, so that means if we add you now, did you get the link that I sent you to add yourself? A lot of us were down. That's not good. That's the old link. Oh, come on. All right, hold on. Let's try again, guys. So you guys can see me. That's a good sign. That is a good sign. I got to get into the StreamYard on my phone to be able to hope it's sending old links. And I think the only way to do it was to end it and restart. It seems like StreamYard had some sort of glitch out when they had an issue with X. So just give us a second so we can, hold on, let me mute myself real quick so I can enter the studio. Still going to my old one, so hold on. Me and StreamYard are gonna get a fight. That should be the right one, freak. The boundless is 02. All right. Well, we're getting us back up and running right now. The only way to do it was to literally cut it off, conk it out, and then restart it. So that's literally what we're doing right now. I apologize, folks. It's not my fault. I apologize. Yeah. We'll go back to where it ended. We're almost up now. You just gotta give us 1 second. I promise. I apologize, guys. It went out on all of us, and the only way to do it was to close it out and then restart it. So it gives me anxiety. My anxiety is at like, a ridiculous level at the moment. I hate that. That really gets on my nerves. Unacceptable. Unacceptable. things do happen, but that's my luck. You know, that's my freaking luck. All right, here we go. Here we go. Back to where the spot so we don't miss anything, okay?
Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the hoodie. In this regards questioning and representations and questioning by Mr. Brennan.
And granted a mistrial.
And need to do, Your Honor, is to have two documents marked as exhibits. And then I am going to use exhibit 88, which is an evidence, which is the hoodie, which is why I'm putting on the evidence gloves. And it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
What I would like to have marked.
Mistrial. Make that clear.
What I would like to have marked, the first document, and I want to get the specific title. These two documents are from the criminalist's file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the hoodie sweatshirt that's in the crime lab file folder.
Pearl clutching at its finest.
First is the back of the hoodie. So with Your Honor's permission, I would have that marked for identification.
Exhibit YYY.
It's fake anger. It's the fake pearl clutching of, oh, Your Honor, we need a mistrial. They're going to try a billion times great mistrial because they know this is going very, very bad for them. Very, very bad.
Okay.
That is the back of the hoodie, Your Honor. And if I could please have the next
Me too, chicks.
marked
Nice to
in
see
order exhibit for identification.
Nice to see you, my friend.
Exhibit ZZZ for the identification. Just give me a minute to read this, Mr. Leslie.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes in the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay.
That's not what he said. He didn't say, in fact, there were holes in the back of the. That's wow.
I can't tell entirely from ZZZ, but if that's your argument, why for identification appears to support that.
Your Honor, may I have the exhibits marked for identification back for my argument?
Once again, they'll ask for 1 million
Okay.
mistrials.
Thank you, Your Honor. Thank you, Madam Court Reporter.
She has to act like she's seriously entertaining it. I doubt she is.
Your Honor, what we just saw is Attorney Brennan question Dr. Wolf with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is the, what happened was Attorney Brennan held up the casing with a hoodie sweatshirt, went to the back of the hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor.
Okay.
The first time I realized that line of question was going to be asked was when Mr. Brennan pulled the casing out.
Okay. Go ahead, Mr. Leslie.
Thank you, Your Honor. So to do it in order, Mr. Brennan takes the hoodie sweatshirt in the casing without notice, shows it to Dr. Wolf, and shows the back of the hoodie, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now? It would help me if you held it up for me now,
Absolutely, Your
Mr.
Honor.
Alessi.
So here is the back
Okay.
of the hoodie.
Okay. All right. Thank you.
It's very obvious that these are cutting holes cut by the criminalist. And I'm going to get to back to this in a moment. But I would like to do it and certainly entertain any of your Honor's questions, but in a logical order.
Sure. So I'm not, what about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your Honor.
Okay. All right. Thank you. Go ahead, Mr. Alessi.
Thank you, Your Honor. So I just want to get the flow back going here in the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up. We have no idea that this was going to happen. Goes up, confronts the witness, Dr. Wolf, shows the back of the hoodie sweatshirt. To my knowledge, the first time the back has been referenced of the hoodie sweatshirt. Shows Dr. Wolf, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolf is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29th, 2022.
So do you have something you said, when you said obviously cut by the criminalist, do you have something that shows that chart that I couldn't understand quickly? Is it on that?
Yes, Your Honor.
back?
What
Okay.
we have is two documents to show that.
Right. So the second one, when was that provided?
These, when you say provided, you mean with regard to when did the defense get these in
Yes.
a discovery? Let me get the date, Your Honor.
Sure.
By the way, we're a
Notice
little
of
behind. Why
discovery,
is he
May
still going?
2023.
Okay, thank you.
And I will note, Exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie, I believe is the only one, to my knowledge, not put into evidence, not turned into evidence. This is the one that it clearly shows the hoodie before the criminalist started her work with the cuts. There are no cuts to YYY, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right. So is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolf. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to Exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top. LIMS 22-2184, analyst MSH, which is the initials for Ms. Hartnett. Dates: May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the...
You know what? Can you bring it up to me, please?
I certainly can, Your Honor.
Somebody catch up Hodor real quick.
And I can conduct my argument from right here if that helps, Your
I
Honor.
just want to point out to me where it says, where it shows the back.
This is the back. So you can see the back of the hoodie. That's the back of the hoodie head. And then you can see the very...
Live Brendan is up right now, unless he just stopped.
Let me just get a check on this, Your Honor. I'm not...
Mr. Brennan, you should come up and look at this as well.
Thank you.
And I'm
So Mr. Leslie, stay here.
yes.
All right, so this is why. I didn't see there was nothing said that should have been. It was shown here, Mr. Leslie, says exterior front.
Can I get the
Well,
check?
the label cuttings.
Pardon me?
The label cuttings.
Right, but if I can, Your Honor, I want to clarify this. Yes, are you willing just to let me just make sure I get...
Mr. Jackson, it says exterior front, what Mr. Leslie was pointing me to.
Well, yes, sir. It may print the wrong page. I can do it, but Mr. Wolf, can you print the back? And Your Honor, are you comfortable using the computer at the back? Because I think we just had the wrong one.
We need to mark it, though.
I understood. We will. He's printing it right now.
No mistrial, folks. None. Just an instruction to the jury. Hank said he made a mistake not knowing that it wasn't from the criminologist, and he actually offered remedial of they can enter the lab report in and say to disregard. So there is no mistrial, folks.
And the back to show all the cuttings, but what only printed out was the front. We are now printing the back. Your Honor is correct.
A whole circus. Simple jury instruction, folks. That's what's going to happen. Why didn't Jackson object to the question? Good question.
But maybe, Your Honor, I'm advised it will take 2 minutes because it has to go.
All right, so go ahead with your argument.
Thank you, Your Honor. So, Your Honor, what is being printed is which we will mark, will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than the
So
criminals.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And here is the reason for the motion for a mistrial with prejudice. On its own, to do this, and you put together all of the parts of what just occurred. You start with the fact that and if I could, Your Honor, now that I have it yet marked so I can then refer to it.
All right.
Thank you.
Can you print extra copies too, so I can have my own copy?
Absolutely.
And for the Commonwealth to see?
And I'm going to show the Commonwealth what I just printed.
No, the jury's not present.
Exhibit A.
Thank you, Madam Court Reporter. Sure.
Mind you, unless he's still having a fit over the instruction the judge is going to give. And it's actually not even an instruction, it's from the judge herself. So they still haven't brought the jury back in though, right now.
Well, Mr. Brennan is reviewing that. I may head to Madam Court Reporter, the chain of custody document for these, and ask that he mark is the next exhibit in order.
Okay.
And then with Your Honor's permission, I would have Madam Court Reporter hand them both up to Your Honor so
Sure.
Your Honor can see what I'm referencing.
Thank you.
Oh, wait, and there's a lot of you here, I'm supposing, because other channels are down, 747 total. Do me a favor and strike that like button. I'd appreciate it.
Here it is. Thank you, Madam Court Reporter.
Share with some friends. And if you can donate to the channel, it's very, very helpful. We're still a growing channel here.
Do you need this, Mr. Leslie?
I do not need either of them, Your Honor,
Okay.
and I have the extra copies as well. Okay, so Your Honor, I now have enough copies for Your Honor and for the Commonwealth.
Oh, thank you.
So if I could have one set, that would be great. Yeah, Your Honor, thank you.
Unless he's still whining, folks. Welcome, J-Rock.
All right. Thank you. Okay, go ahead, Mr. Leslie.
So, Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist, Ms. Hartnett, with the back of the hoodie with no holes on it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document
and notches
that describes the chain of custody for the hoodie and the cuts in the chronology.
Yes, they are theater for the cult. You are right.
And of course, we have exhibit 88, which is the hoodie. So what Mr. Brennan did, and I'm now pulling exhibit 88, he holds up the back of the hoodie, which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case, Ms. Hartnett, she's testified, and Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes in the back of the sweatshirt that were dramatically held up and confronted with Dr. Wolf, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows
That is
from its own documents, from its own criminal list, that those holes in the back were caused by their criminalist as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision that never occurred? That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is
intentional and it is remedial. Stop
on the key issue of this case, whether there was any collision at all.
My hands.
On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that what just happened, and I'm not going to repeat or go into other than to reference.
But you have.
This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, the Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right.
And
So let's move along from
right.
that.
That's what, and I'm going to come back to this.
Yeah, move along, sir.
Why is this occurring, Your Honor? Why is this happening?
They did not get a mistrial.
The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolf, the ARCA expert, to try to make it seem like Dr. Wolf didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolf on were caused by the Commonwealth's own criminalist as part of sampling. I don't believe one could come up with more misleading, misdirecting, elucidation of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one and the only one of the, with regard to the hoodie, the back of it's not in, although the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion in that this is intentional.
Desperate. That you're desperate. That's
that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice. The
So the judge
amount
thinks about
of
that.
effort, the amount of work, I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense. That should befall the prosecution. Ms. Reed,
Too bad it doesn't.
again, is entitled, like every other defendant in
No,
this
she's entitled, all
wonderful
right.
Commonwealth,
She's
to a
entitled,
fair
all right.
trial. The prosecution is supposed to be held to a higher standard, to do justice,
Oh,
to
then you?
create a fair trial.
Higher
This is the antithesis of a fair trial. Miss Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear the more desperate the prosecution gets because it can't prove its theory, including
They have
its own
proved the theory.
medical examiner
Times 10, sir.
can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point,
You're right.
Ms.
And
Reed's
your client's
rights
on
have to be protected. At some point, confidence in the judicial system, the public's
know.
confidence in the judicial system,
There's
that
no confidence in
prosecutors
you.
will conduct themselves with their duty to present a fair trial. That has to be enforced at some point
Oh,
for
shut
Ms.
up.
Reed to receive the fair trial that
She's
she
received more
and
than a
every
fair
other
trial,
defendant
sir.
in this
clown.
Commonwealth is entitled to.
You are a clown.
All right, thank you. Mr. Brennan.
And Brennan keeps it like 2 minutes. I kid you not. 2 minutes, and he's done. Inadvertent, give them an instruction, end of story.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake.
We're a little behind.
And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr.
Yep.
O'Keefe's sweatshirt.
He stopped because she stares at
The
him.
parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury they are to completely disregard any questions or answers about the holes in the back of the sweatshirt.
Poor Randy.
And the court should allow the defense to introduce the lab paperwork.
All right.
Here it is,
So
folks. No mistrial.
I'm not going to allow the mistrial motion, Mr. Lessie. What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z,
Honk, honk.
A, and B. 4 of each letters. I'm going to put all these into evidence. They can be displayed for the jury, and I'm going to instruct the jury that during the cross-examination of Dr. Wolf, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or
sounds
something
like.
like this.
Talk about that.
I instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th, 2022. I instruct
know
you
they're
further that those holes were made
The only help they have
by
is
the
call mistrial.
criminalist Ms.
They're losing.
Harnett during the course
Hard.
of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can I see those, please?
He does have a conscience.
It's
And to
unclear for me. Do you have a better idea, Mr. Lessie, what day these were done? Is it all of those 3 days? Now I see a 4th day. 5/11, no, I'm sorry, 5/11, 5/12, 5/11/2022, 5/12/2023, and 6/18/2023. Those are the 3 dates.
Your Honor, on or about May 18th, when the
I love
defense
that.
filed a motion to test. So those, that's the probative date.
So May 18th?
Yes, that's,
Okay.
and that's 2023.
2023.
All right.
Yes, we know, Yelesi. Lilesi.
That's what I'm going to do. Is there anything
aware.
further you want me to include in the instruction? Your rights are saved regarding the mistrial. I disagree with you on that.
Your Honor, I'm not going to go any more into the argument, but I appreciate the opportunity to provide perhaps some further instruction for Your Honor.
So I'll hear you. Go ahead.
So the
Oh,
first,
God.
Your Honor, is with regard to two things. One, I would like the opportunity to have the hoodie sweatshirt
I would like
held
you to
up,
shut up.
because that's what
Okay.
happened.
Yes.
in
Yes.
these holes is
Yes.
that-
Yes.
Thank you. So that's number one as part of the stipulation, and then.
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they
Very
they
instruction.
cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a
Exactly.
stipulation. It's from me, which I think is more forceful.
I misspoke, Your Honor. I agree,
Okay.
not a stipulation, but.
Just kind of
as Your
done with
Honor
these
said,
guys right now.
With regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview.
Oh, God, the
Your
rock.
Honor said that rock wasn't present, on or about the time of event.
So I do say that when I say Ms. Harnett did this. So rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes were a result
My God, he's still whining.
of the events on January 29th, 20. So all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it.
I'm on-
All right, we can bring the jury in.
Oh,
It's what I said, Mr. Alessi.
Your Honor, I was consulting with Mr. Leslie. I'm not showing disrespect to the court.
Okay.
Of course,
you are showing disrespect
All right.
to the court.
So it's what I said, Mr. Alessi. I instruct you that you're not permitted to draw an
Yeah.
inference.
Groundwork for appeals. I
that
mean, standard for what their
the
games
holes-
they've been playing.
came from the events of January 29, 2025. Those holes were made by the criminalist Ms.
kinda
Harnett during the
did.
course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible,
love you,
Your Honor,
Greg.
last comment, to instead of not drawing inference, you
Oh
should
my God.
conclude that these holes were not present in the hoodie sweatshirt.
You weren't listening, sir.
Caused by the criminalist,
So I can just leave that all out then and just say, Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist Ms. Harnett during the course of her inspection and sampling of the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring them in, please.
Judge, just as a housekeeping matter, the sweatshirt's been taken out of the plastic sheet, and it might need to be remarked. The plastic sheeting was marked, but if we're going to put it into a bag or something like that, we might need to have it marked, but we don't need to do that right this second.
Oh yeah, I was on the Court TV
Yes.
Law Crime Boston 10, one of those, and they were going nuts. There were also a lot of people saying the defense is desperate. This is so desperate. There's no mistrial happening. This is so crazy. Alessi, sit down. Like the comments were going real fast. I was about to say,
All right, thank you. I'm sorry.
all three of my daughters had less tantrums when they were toddlers. Just saying. Just saying. Howdy, Judy.
Mr. Alessi, you're simply going to stand and hold the sweatshirt, right?
yes, Your Honor.
Okay.
And do the hokey pokey, and he turns himself around. I mean, come on, Alessi.
Counsel, this is exhibit 223.
Right?
In Your Honor, I would hold it as Your Honor begins to read Is that?
By like demanding a mistrial.
No, I want you to hold it up with the back.
What would you like me to start with?
You do that first and then I'll give the instruction.
Thank you, Your Honor.
You look like a fool, and I'll read the words.
All right, so Mr. Alessi, why don't you just, where are you going to stand?
Pardon me?
Where are you going to stand?
I would suggest, Your Honor, right about here.
All right? So you can
Then do it.
stand there, you can hold it up, then I'm going to ask you to put it down, and then I'll give the instruction.
And then I will return it to Mr. McDermott for the court officer.
Yes,
Thank you.
court officer.
Bear with me a moment, Your Honor. I'm going to put on the.
Gonna
All
put
right,
on
then
some
we
more
will take the
gloves.
luncheon recess. When we come back, we'll have the voir dire.
Fuck's
Or
sake,
actually, is
bro.
Dr. Lapisada here?
She's here, but she's not next. We're gonna call up.
She's not next.
John T.
For just the measurements?
Go ahead.
Oh, for fuck's sake.
Your Honor, we're not going to be able to show the exhibits from Ms. Hartnett or the cuts along with the next after to show the cuts were made by Ms. Hartnett.
Well, I
They
say
are.
it and I'm going to tell her what they are, so.
Just because you're yelling doesn't make you right. He just likes to, yep, for not doing her job and also being disqualified as a witness when she tried to play accident reconstructionist, and a judge disqualified her as a witness, as an expert witness for that on another case. It's a circus, an absurd circus, and John O'Keefe deserves better. His family deserves better. Everyone involved in this, top to bottom, deserves better than this. Except for the one and only Karen Reed, who created this effing circus herself, and her really shitty attorneys that have no problem lying to the court, having no candor to the court, breaking
Jurors, I
orders, and then getting up there.
appreciate your patience. Mr. Alessi, why don't you
With
hold
their
the
pearl
exhibit up
clutching.
for the jurors, please?
Come on. No, this is the instruction to the jury that Alessi whined and bitched about like a baby toddler. My hand.
All right, jurors, that's the back of the sweatshirt
You look so
that was
cool.
shown to Dr. Wolf.
Is he serious? All right, with the theatrics.
Okay,
Cool. They can see it,
thank
sir.
you. Why don't you go ahead
Put
and
it
put it
down.
back in the bag?
Oh, she clearly was. Supposed to be a voir dire.
So
Now,
jurors, I
saying yes,
instruct
no.
you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So I know your lunches are here, but I think Mr. Yannetti, your next witness, please.
John T.
They're going to do the measurements real quick. The measurement guy. I agree, V. Harley. I agree. Do me a favor, guys, while we're waiting on this witness, hit the like button, hit the subscribe button. If you can donate to the channel, it would be very helpful. We're still trying to grow. We're a very small channel. We'd like to keep bringing you this kind of content, and we rely on your kindness to do that. We have options like Venmo, Cash App, PayPal, and we have links for those of you who just want to use credit or debit. I keep everything anonymous. I don't read anything but your screen name. If
All
I
right,
know
good
it. If it comes
afternoon.
through your real name, I do not read your real name.
Go ahead, Mr. Yannetti, whenever you're ready.
Thank you. Good afternoon, sir. In a good loud voice, would you please state your name and spell your last name?
Sure. My name is John Tedeman. It's Tedeman.
Do you work, sir?
I do.
What do you do for work?
I am a private investigator.
Do you work for someone else or do you have your own firm?
I have my own firm,
What is the name?
Forum Investigations.
And that's Forum?
Correct.
I'd like to ask you a little bit about your education and work history.
That's the shady
You're
guy?
from this area?
Yes, Boston
Where-
proper.
I'm sorry?
Yes, from Boston.
Proper.
Where did you attend high school?
The Roxbury Latin School,
When did you graduate?
1996.
Where did you go to college?
I went to Princeton University,
What year did you graduate?
2000.
What did you do after graduation from Princeton University?
I became a federal agent.
Where?
The agency or the location?
Oh, I meant the location. Sorry.
I started out in Los Angeles and then I was back in Boston.
And
Good
what
for
years
you.
were you a federal agent in Boston and Los Angeles?
2002 through 2008.
And what agency did you work
It's in
for?
here.
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations, all sorts of things, anything involving a Social Security number, basically.
And why did you leave in 2008?
I went to law school,
Where?
Suffolk,
What year did you graduate from Suffolk Law School?
2013.
And what did you do after graduation from Suffolk Law School?
I've had a small solo law practice and worked as a real estate broker,
And what type of law did you practice?
mostly real estate law.
When did you start
Clearly.
forum investigations?
In April of 2024.
Last
Are you
year.
still practicing as a lawyer?
Not very much, no. I still have my license, but my bar card, but I don't practice much.
How did you
Shocker.
become involved in this case?
I was
Yeah.
contacted by somebody from your office last Tuesday, I believe, the 3rd.
Shock. Last Tuesday.
And was it explained to you why you were brought in
Last
at this
Tuesday.
late juncture?
Yes, it was explained that there was another investigator who had a health issue and would not be able to testify. So would I be able to help out with a small assignment?
All right, and what were you asked to do?
I was asked to travel to 34 Fairview Road in Canton and take some measurements and photographs.
Did you agree to do that?
Yes.
When did you go?
On June 3rd, I believe I arrived about 5:30 at 34 Fairview.
Okay, and when you say June
It is
3rd,
crazy.
we are talking
Last
about
Tuesday.
last.
Yes,
Correct.
last week, yes.
Whom did you see when you got there?
One of the homeowners, an older gentleman, greeted me when I pulled in the driveway.
All right, and it was not the Albert family,
You're so
correct?
gracious,
It was
Brave.
not.
Did that individual give you permission to enter onto the property?
He did.
What did you bring with you?
I brought an iPhone as a camera, and I brought a wheeled measuring device.
All right, and can you describe what a wheeled measuring device is?
Yeah, it's like a handle with two wheels at the bottom, and in the middle there's like a little odometer that measures feet and inches.
And
Be right back,
if
guys.
we
I got a
could,
conspiracy
Mr. Wolf,
bathrooms.
we display the photo of the front of 34 Fairview that's already in evidence with the court's permission.
Yes.
And what exhibit number is that, Mr. Wolk? 46? Do you see exhibit 46 on the screen, sir?
I do.
Do you recognize that?
I do.
What do you recognize that to be?
That is 34 Fairview Road in Canton.
When you got to 34 Fairview Road in Canton on June 3rd, did you make note of the various entrances to the residence on the front, from the front of the house?
I did.
Could you describe those for the jury?
Yes, on the left side center of the building, there's what I would call the front door, up those 4 steps, I guess. Then if you were to look farther to the right, there at the end of the main building, there's another door, which I guess is the second front door or side door.
And with regard to that door, is it fair to say that faces outward, faces toward the road?
It does. It faces directly towards the road.
Okay, continue, please.
And then past that to the right, there are the windows. And then if you can see the little red line, that is a side door that goes into the garage. Yes, right there.
It's been highlighted there?
Yes.
Okay. And then there are obviously the 2 garage doors.
Then the 2 garage car doors. Yes.
4 cars to enter. Okay.
Yes.
We can take that down. Mr. Wilk, and put the lights on. May I approach the witness, Your Honor?
Yes.
So I've placed a photograph in front of you. Can you identify that for the jury?
Yes, that appears to be a photograph that I took of the side front door, the secondary front door, garage door and the two car doors to the garage.
Okay, particularly with regard to the side pedestrian entrance into the garage, the red door that you identified in the previous exhibit. Does that photograph fairly and accurately represent the layout of the house in terms of the outside and the entrances that you've previously testified to?
Yes, it does.
I would offer that, Your Honor.
All right, can I see those, please, sir?
Well, that's a sidebar. I think that's number 6, if I'm not mistaken. But since we lost the feed earlier, I can't be sure. But I think it's number 6. Do me a favor, folks, hit that like button. Appreciate it. If you're on X, there's 804 of you currently watching between 2 platforms. If you're on X, come on over to YouTube. We have a live chat. I think you would enjoy my live chat. We have some very smart, funny, interesting people in our live chat. Well, that's it, right? They're just, this guy's only supposed to be talking about measurements. That's it. That's all he's supposed to be testifying to. Measurements from the door to the flagpole or whatever. So there's nothing more he's supposed to be. But that's the thing. Why is it that, it was the basement. Remember, JMS? It was the basement. Now it's the garage. You know, it's just the goalpost moving more and more as we go. It has been since I started covering this case in 2023. With all the misinformation and lies that have come out of the defense and their paid shills, it changes. It changes based on information that comes out that proves that something they said couldn't be true. You know? It's the truth of the matter. I'm not going to lie. They haven't had lunch yet. She's talking about lunch, and I'm still thinking about mozzarella sticks. I kid you not. The podium pounding is for, you know, the dramatics. It's all for the dramatics. Everything is for the dramatics. It's to run the cult and have them get on social media and be like, oh my God, this is so bad. It needs to call a mistrial. Bev's so corrupt. She didn't call a mistrial. No, there isn't any. For Alessi to actually sit there and say the Commonwealth has no case and they're desperate when it's very clear that the defense is the desperate ones. They've tried for a mistrial and a motion to dismiss and a motion for directed verdict. The Commonwealth only objects when it comes to form or something that they were already told they weren't allowed to bring in. As you notice, Hank doesn't object all that much because he knows, just like I know, they're making fools out of themselves. Let them keep making fools out of themselves, you know? But it's the whole pounding of your fists and screaming and yelling. It's, you know, somebody must have taught him that doing that makes people think he's right or something. Just all the screaming and yelling and, you know, the fake pearl clutching of the Commonwealth did something so bad by making a small mistake that we need a mistrial. Sir, you have lied to the court. You have snuck around orders, broken orders, clearly talked to witnesses you weren't supposed to in the middle of their testimony, directed them to say and do certain things that you're not allowed to do, okay? And then you come up here with your fake outrage. Save it, dude. Save your fake outrage. Nobody in that jury is an idiot. Let's make that very clear. The jury is not stupid. It's not made up of stupid people, okay? It's made up of everyday normal people like you and I. And they certainly can see through nonsensical bullshit when it shows itself. You know, they must, you know, nibbled on his arm, you know? The basement, yeah. I mean, what does that make Nick Rocco look like? And let's make this very clear. Karen doesn't care what it makes Nick Rocco look like because, well, he did his job for her. And so if it makes him look like an idiot, who cares? Karen doesn't care. You know? They do think that the objections mean winning. It actually does the opposite effect if you object too much for the jury. So that's how much they know about actual trials and the law itself. So they probably do. You're probably right.
Okay, Mr. Wolk, whenever you're ready, if you can.
Yeah, it was
display
jazz
that
hands, you know? God damn it! God damn it, everyone! That was the whole spiel with Alessi. Like, make it dramatic. You know? Usually, judges will tell them to tone it down. But we know that she's not going to, you know? Struggling to put them on. I didn't see that part. I must have missed that part. Right? If they don't fit. Yeah, money, raising money, and it still is. Raising more and more and more and more money.
you see
The
what
amount
has
of money
been-
they
So I'm
throw
going to
at the
ask you to take that
conspiracy.
down. Folks, we're going to take
Nope.
the luncheon break at this point.
Oh, shit.
Rise for the jury affairs, right this way, please.
They tried to sneak that in. Oh, no. Oh, no. Well, folks, the defense just tried to sneak a picture in because, as Mr. Hank Brennan so eloquently pointed out, they only wanted to do this measurement thing as a way to try to say that it happened in the forgot. So this is what this man can testify to. He is not allowed to testify to what he thinks or doesn't think. Complete the measurement, and that's it. And look at how annoyed she is. She's ready to go out before she says
All
something.
right.
She is annoyed.
So we'll fix that during the luncheon break, Ms. Giannetti, to what I said. All right. So can we get Dr. Laposada in here? We'll do a very brief voir dire of her.
I hear you, J-Rock. Me freaking either. It's a daily basis with these people, you know? And I get harassed into oblivion on a daily basis. So, you know. Oh, she's annoyed. All right. Oh, they have no shame. You have no idea the amount of shame that they do not have. You know? And you can't fix stupid, right, Jay? We can't fix it. So it's like, does anybody think about the things that they say before they say it? And then you have to go in and be like, did you even think about what you just wrote before you wrote it? They don't. They just repeat talking points that they've been told. That's the frustrating part, is they don't take a minute to do any research of their own. They just parrot what someone else said. Oh, so much, please. So much. So much.
Do solemnly swear the evidence you have before in case you have the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. Good afternoon, Doctor.
Good afternoon, Your Honor.
We're going to do a brief voir dire, okay?
No problem.
Thank you.
Oh, thank you, Trisha. I saw Trisha's 10 euros.
All right,
I think
Mr.
it's
Jackson,
euros
Foundation,
donation
just those 2 points,
on
please.
Revolut. Thank you, Trisha.
Sure.
If anybody else wants to donate to the channel, this is how you can do it. We also have a link for those of you who want to use just credit or debit and don't have any of the payment apps. Thank you, Trisha. All right, come on, lady. Now this lady's a disaster. Let's throw that
Your Honor,
out
for
there.
purposes of expediting, does the court wish for me to go through the foundation of the doctor's education, training, and background and experience, which is going to take a minute?
Yeah, no, just focus on the foundation for the dog bites and focus on the foundation for what's been termed to be perhaps biomechanical engineering evidence, those 2 areas. And if there is support or methodology in Dr. Laposada's resume to point
To it.
to exactly where that is. Okay?
Yep.
And I expect this whole voir dire should take no more than 15 minutes.
I'll do my best, Your Honor. Doctor, could you please state your name for the record? Spell your last name into the record, please.
Yes, Dr. Elizabeth La Posada, that's spelled Laposata.
Dr. La Posada, what do you do for a
Yes.
living?
I'm a medical doctor subspecializing in forensic pathology.
Dr. La Posada, I'm going to move very, very quickly past the bulk of your training and experience over decades. I'm going to ask you a couple of quick questions. Where did you get your medical degree?
University of Maryland School of Medicine.
And do you have any subordinate degrees to your medical degree?
Yes, I have board certifications in anatomic and forensic pathology.
How long have you had
Yeah.
those board certifications?
She has the right.
35, 40 years.
Have you ever worked as a medical examiner in any capacity?
Yes, I have.
Have you ever worked as a chief medical examiner for any agency or governmental agency or state?
Yes, I have.
Describe that to the court, please.
I was a chief medical examiner for the state of Rhode Island for 12 years.
How many autopsies would you say in general that you have conducted yourself?
Over 3,000.
How many autopsies in your experience as a supervisor in one capacity or another would you say you've supervised over your tenure?
Over 7,000.
Of those 7,000 that you have supervised, have any of those dealt with motor vehicle incidents?
Many,
Have any of those dealt with motor vehicle and pedestrian incidents?
many.
Give me an idea, if you have a number in mind, how many motor vehicle pedestrian autopsies you have been involved with, either directly or from a supervisory standpoint.
Hundreds, over 500 at least.
Now let's talk about why you're not the medical examiner
Do
anymore.
you have a significant background and training in the cause and manner of death?
Yes, I do.
Is that the main goal or the main job or duty performed by a medical examiner?
Yes, it is.
Is it also significant in terms of supervising other subordinate medical examiners who may work under your charge?
Yes, you have to make sure they're doing it right.
And you didn't.
Is there a methodology that you have employed and that is standard in the industry to employ, including differential diagnoses and inferential thinking in terms of coming to conclusions related to manner and cause of death?
Yes.
Can you explain that for the court in brief, please? I know you probably have a very lengthy explanation.
Okay.
Do it as briefly as you can, with being as succinct as you can.
Certainly, to determine cause of manner and death, we look at scene investigation, autopsy findings, police and witness statements, and medical history. And using that information, we come up with a differential diagnosis or a list of
She was told to say that.
things that might have
Differential.
happened to that person to cause them to die. And from that list, then we see where all the science and all the data, which one it supports. So we've looked at several different things. I always told my staff, I said, how can we be wrong? What else could this be? So you have to make what
Please.
in medicine is called a differential diagnosis and then see what the facts support.
Did you employ a differential diagnosis in this case?
Yes, I did.
Do you have to be at the scene in order to understand or analyze information that you get in a police report or photographs or things of that nature?
No, that we use the police investigation and scene investigation, crime lab reports, photographs taken by the crime lab, by the police at the scene.
Have you qualified as a expert forensic and anatomical pathologist in other courts in Massachusetts and other states?
Yes, I have.
Approximately how many times would you say you've qualified?
Hundreds.
I want to talk for a specific for a second about a specific area of interest for the court. Were you provided information and photographs of John O'Keefe's arm and his arm injuries included with the rest of the autopsy information that you received?
Yes.
Were you asked to make a determination about the nature of the wounds specific to his right arm? I know that there's other injuries to Mr. O'Keefe, but I'd like to relegate your attention to the right arm.
Yes, absolutely. That's what the forensic pathologist does.
without telling me what your opinion
Hey,
was,
Mark.
were you able to come to an opinion or conclusion about the source of those injuries?
Yes, I was.
What methodology did you employ to come to that opinion or conclusion, or those opinions and conclusions?
My experience and knowledge and training, along with the appearance of the wounds on the right arm, which fit a pattern, and then knowing that it fits a pattern, then I can try to look for, okay, what is the item that caused this pattern? And that would be part of the differential diagnosis that I've used for many, many years in making diagnoses and determinations.
Have you ever been trained in pattern recognition?
Yes.
In what capacity?
Oh, as a forensic pathologist and medical examiner, a large amount of our work has to do with recognizing pattern injuries, because that's so important, because it gives us an idea of what might have caused that injury. And then that's clearly of a lot of importance to the police and the investigators as they're trying then to say, well, what could have caused that injury? And so the forensic pathologist could say, well, I think it was X or Y. Then they can carry out their investigation armed with that information as to what might have caused the injury on the body.
Is there such a thing in the world of pathologists as medical literature or academic literature that deals with pattern recognition?
Yes,
Are you familiar with some or most of those publications?
absolutely.
Have you ever yourself taught classes on pattern recognition?
Yes.
At what level? High school, graduate school,
At
medical
the
school?
medical school level.
How often have you taught courses on pattern recognition?
Oh, at least a handful.
When was the last time you taught a course in pattern
Handful?
recognition?
Let's see, last month.
Do any of
Last
the
month,
courses
but only
that
a
you've either
handful.
taken, well, let's take them one at a time. Have any of the courses that you've ever taken dealt with wound pattern recognition as it relates to animal wounds
Courses that I've taken.
that you have taken?
It's part of our basic training and understanding of a forensic pathologist. The board exams we take test for that. Those injuries are described in our basic forensic pathology and medicine textbooks. They appear continually in our medical and scientific journals.
Is that an important skill set to develop, wound pattern recognition as it pertains to animals as a forensic pathologist?
Absolutely.
Do any of those academic courses that you've either taken or reference works that you just referred to, do any of those deal with dog bites and claw marks specifically?
Oh, yes, they do.
In the course or courses that you have taught related to wound pattern recognition, have you ever taught on the subject of dog bite wounds and the recognition of dog bite wounds?
Yes, I have.
When was the last time you did that?
Let's see, it would be in the course in the medical school. Would have been several years ago.
Doctor, with regard to staying with dog bite wounds specifically, have you ever performed an autopsy that specifically dealt with dog bite wounds, known dog bite wounds?
Yes,
So you've seen them in person.
yes, I have.
How many? 5, 10? How many?
Have you ever been qualified in any court in the land, state or federal court, on the issue of wound pattern recognition as it pertains to dog bites?
Yes.
When was that?
Which court?
The last one I can recall was a federal case involving questions of a police dog.
Yeah, canine.
Did you engage in that case? Did you engage in a differential diagnosis to determine, in your opinion and conclusion, your expert opinion and conclusion, the source of the wounds that you saw?
Yes.
Did the court qualify you to speak on that issue in court?
Yes,
Did you in fact testify in furtherance of your opinions and conclusions in that case?
I
Oh,
did.
yeah, they are.
I want to turn for a second to motor vehicle accidents or motor vehicle incidents.
You'll catch up.
Do you also, some of the same questions, have you also performed autopsies on known motor vehicle pedestrian incidents?
Yes,
How many times would you say you've performed an autopsy on those issues?
hundreds, maybe even 1,000.
is that a relatively common occurrence, as sad as it may be, motor vehicle pedestrian incidents in the field of forensic pathology?
Yes, it is, unfortunately.
Have you performed autopsies personally as well as supervised autopsies on motor vehicle pedestrian incidents?
Yes.
And what methodology do you employ in furtherance of coming to opinions and conclusions regarding cause and manner of death specific to motor vehicle pedestrian incidents?
Well, we look at the scene investigation. We look at what the motor vehicle looked like. We look at hospital records, the autopsy, and then trying to understand how the injuries that the pedestrian sustained, what those mechanisms were, and how the injuries show that that person interacted with the motor vehicle.
In doing so, in coming up with injury mechanism analysis, is it important to look at and analyze the actual vehicle that is allegedly involved?
Yes, you want to look at photographs of that or see it in person.
Is that part of the normal methodology that is employed in the field?
Yes, you must look at the photographs. You must see what the vehicle looks like.
Do you also look at the other side of that handshake? In other words, look at the body of the individual that was in your case, killed, the decedent, in order to marry the two and determine whether or not the cause and manner of death had something to do with the motor vehicle, a motor vehicle impact?
Absolutely.
Describe that for us, please. What are some of the things that you look for that's part of the normal methodology that a forensic pathologist employs?
Well, when we examine a fatality from a motor vehicle, we want to try to understand what led up to it, how the impact occurred, and then what happened after. So we would study information about the injuries to see if we can relate them to certain pattern injuries that would be on the car. There are also evidence of transfer of energy and injuries that can result from the transfer of energy. So using the body, looking at the scene and the vehicle, understanding the motions of the vehicle and how they would have produced or would not have produced certain injuries on the body.
I'm going to take them one at a time. With regard to animal wounds or dog bites, were you able, in this case, using differential diagnoses, using inferential thinking, and using the skills that you've developed over decades of your education, training, and background, were you able to, without telling me what the conclusion is, were you able to come to a conclusion or opinion as to whether or not the wounds that you saw on John O'Keefe's right arm were consistent or inconsistent with a dog bite or claw marks?
I was able to come to a definite scientific conclusion.
And is that conclusion to a reasonable degree of medical certainty?
Yes.
Is it to a reasonable degree of scientific certainty?
Yes, it is.
Is it consistent with the training and methodology that you've employed over decades?
It is.
I'm going to ask you the same series of questions with regard to the motor vehicle incident. Did you review the autopsy report in an effort to look at John O'Keefe's entire body and all of the injuries that he sustained, not simply his right arm?
I looked at everything.
In doing so, were you able to come to an opinion or a conclusion as to the mechanism of injury and whether or not his injuries in total were consistent or inconsistent with a motor vehicle incident or impact?
I was able to come to a scientific conclusion.
And without telling me what that scientific conclusion is at this point, did you employ the same methodology that you've explained to the court earlier concerning differential diagnoses, inferential thinking, and decades of training, the education, training, and background that you've described for the court in coming to your conclusions about whether or not the cause and manner of death was consistent or inconsistent with a motor vehicle impact?
Yes.
Your Honor, is there any area that I have not covered to the court's satisfaction?
So I'll let Mr. Brennan ask
Why
questions.
would that take
I may
people
have
off?
questions.
That's weird. Why that? I mean, a mistake can be made. It's human. We're humans. So why would that make
Good
them
afternoon,
mad?
Dr. LaPosada.
Good
That's
afternoon.
So weird.
If we could start with dog bites.
Yes.
Yes.
Did you have any specific training in wound pattern recognition regarding dog bites?
Yes, it's in our literature standard textbook. It's
Oh, it is.
standard information that
by
is
the way.
needed to be a forensic
Not.
pathologist.
For dog
When
bites?
did you receive training regarding pattern recognition of dog bites?
Beginning when I took my board, starting in 1983.
It's not on the board.
And what did that entail?
It entailed reading literature. It entailed reading the standard forensic pathology and medicine textbooks. And it is a sub-part of understanding pattern injuries. Dog bite injuries are described in all our journals and all our standard forensic textbooks.
Other than reading about it when you were studying for your boards, did you have any practical experience where you were engaging in the field in pattern recognition analysis regarding dog bites? early
Yes,
on?
yes,
And
I've
you-
had many
When?
cases where there have been dog bite injuries.
When you were studying for your boards, were you doing that, or after you?
Well,
Completed your boards.
I'm telling you that that it's such a basic part that during studying for boards, it's a section that we study. And I, of course, had many cases since then.
Did you receive any education past reading literature for the boards, where you took classes, seminars, where it taught specifically wound
But they don't.
pattern recognition regarding dog bites?
It's all part of wound pattern recognition. It's usually included in literature. If are lectures about patterned injuries, it's a subset of pattern injuries like hammer injuries, like gunshot wounds, like baseball bat
Not
injuries.
like.
There's a huge number of types of patterned injuries that are part and
Oh,
parcel
yeah.
what a medical examiner has to understand and diagnose.
Do
Oh,
you
wow.
remember taking any specific classes or any specific training
They don't exist. So
about
no.
wound pattern recognition relative to
Dog
specifically
bites.
dog bites?
Yes,
No.
it's in all the literature that I keep up
Lady,
with.
that's not what he's asking.
Did you take any training or did you attend any classes that involved wound pattern recognition of dog bites?
Yes, it's often included in our seminars and case reports.
It keeps
Do you
saying
list
that.
any of those classes or seminars on your resume?
That I took? No.
Can you identify one of those classes, where it was, when it was, who taught it, what the name of it was regarding wound pattern recognition?
No, she
relative to
can't because
dog
they don't
bites?
exist.
I can't give you a specific time
Yeah,
and
of
date.
course you can't.
Can you remember the name of the last class or seminar that you took or completed that has to do with wound pattern recognition relative to dog bites?
I can't recall.
Oh my God, I'm so hungry. You guys are
Is there
killing me.
anything in your report
Sounds
that
so good.
identifies any of your specific education or training on wound pattern recognition as it relates to dog bites?
Nope.
It's in my CV. It's basic knowledge that a forensic pathologist has to have.
No.
I will ask
She's
you
not-
about the CV, but Dr.
not-
Lapasada, I just wanted to ask you about your report first. Is there anything in your report that points to any specific training
In the report that I wrote on
in your
this
report
case,
relative to wound pattern recognition as to dog bites? Is there anything in your report that identifies that for us?
in my report, I put together the case of what happened to Mr. O'Keefe.
Mm,
Okay. As far as your experience, though, do you ever make any note in your report about your specific experience and training about wound pattern recognition for dog bites in your report?
No, it's not appropriate.
In your
Appropriate.
CV, is there
Interesting.
any way you can point to us where you had specific training for wound pattern recognition relative to dog bites, where we can see that on your CV?
No, it doesn't say dog bite training specifically, no.
Do you have anything on your CV that specifically talks about wound pattern recognition for animals?
Those are usually classified within other pattern recognition.
Do you have anything specific that would alert us in your CV that you've had such specific training on wound pattern recognition for animals?
Other
No,
than
that
I've
was it.
passed my board exams and have practiced for 40 years.
Have you provided a list of cases where you have testified in court specifically about wound
Whoa.
pattern recognition of dog bites?
The dog in there.
I don't know if I have given a list. I don't
No,
keep those kinds of lists.
no.
You mentioned one case about law enforcement dogs in federal court. When was that case?
Several years ago.
How long would you say, if you had a guess?
How long was it ago?
Yes, please.
A couple years, around COVID time.
Did you testify in that case about law enforcement police dogs?
I testified about a individual who had injuries, and there was a question as to whether Canine Caper, who was the dog's name, inflicted any injuries on this person.
And this was in Boston federal court?
Springfield, yeah, Boston, right.
Springfield.
Is there a difference between law enforcement dog bites and domestic dog bites?
They have the same kind of dog jaw.
So
They're
you
ta-
would say
they're
that
taught differently, obviously.
would the
Obviously.
wound pattern recognition be the same or different if you were looking at it from a law enforcement dog perspective or a domestic dog perspective?
The dog would be the same.
Oh, it's not what.
Do you have any other cases that you've testified about wound pattern recognition relative to dog bites?
I've testified in hundreds of cases. I can't say that I remember any particular ones.
Would you be able to identify any of those for us today?
No, too many.
Too many to remember about dog bites, lady? Come on, stop
I'll
it.
ask you about accident reconstruction experience. And I mean this respectful, you don't have a biomechanical or a biomedical engineering type background, do you?
No, I'm not a mechanical engineer.
Oh, shocker.
You're not certified by ACTAR or any of those type of organizations, are you, doctor?
No, I relate the injuries on the body to the motor vehicle.
Have you ever been to a car collision scene and investigated a car collision scene firsthand?
Yes.
And when you've done that, do you have a chance to look at all of the physical materials, the properties?
Well, when I go to a scene of a motor vehicle fatality, I look at the pieces that are scattered around. I look at the body. I look at blood stain patterns. I look at damage to the car. And then the body would go back for the examination at the medical examiner's office. And there would be further examination of the scene by accident reconstructionists and examination of the automobile by specialists who could figure out what motor vehicles do. So it's a part of correlating the injuries to the vehicle.
You've never written an accident reconstruction report yourself, have you?
No, that's not what I do.
I understand. In this case, what materials did you look at? Because I don't think in your report it mentions the materials that you studied. What materials did you study as the basis for any potential opinions regarding accident reconstruction?
Well, so you would like for me to tell you everything I studied in this case?
Yes.
Yep.
I have my list here. Should I read?
That's fine by me.
Okay.
No, let her say
I
what she
studied
did. She
the
should remember.
autopsy report, neuropathology report, toxicology, and associated paperwork from the medical examiner's office. I studied 104 autopsy and neuropathology photographs, 70 additional autopsy photos taken by Trooper Watson. I studied Mr. O'Keefe's medical records from the Canton Fire Department and EMS run sheet. I studied the Good Samaritan medical records that also included 35 photographs of the body. I looked at evidence of Mr. O'Keefe's clothing, blue jeans, t-shirt, sweatshirt, boxers, and sneakers. I'm sorry. I looked at photographs that were taken at the crime lab of various pieces of plastic, black, red, and clear. I studied photographs of the outside of Ms. Reed's SUV as it was parked at the police garage. I studied the Canton Police report, incident report, about 100 photographs taken by Canton Police of the outside scene. So that gave me a very good idea of what happened to Mr. O'Keefe.
Were you involved in the case Cromwell versus Daniel Tompkins?
Ooh,
Remind me about that. I've been involved in hundreds of
Finding?
cases.
Yes, you have. This case was in Franklin County Superior Court. It was a case where you had an opportunity to present testimony and regarding blood spatter, which you've been
Oh, yes,
qualified
it-
expert for. And that, I'm sorry.
Well, that doesn't quite say what I did, but I remember the case you're talking about.
Did you attempt, or was there an attempt to have you qualified to talk about accident reconstruction in that case?
Yep.
No, I'm not an accident reconstructionist.
Yes, there was.
And do you remember whether or not there was an attempt that was denied to try to have you talk about accident reconstruction in that case?
I have no idea. I'm not an accident reconstructionist.
Okay.
She does know. Come on.
Have
tell me.
do you have anything on your CV specifically that offers any background on accident reconstruction or accident reconstruction type classes or seminars?
I don't think so.
All right, thank you, Dr. Lafasada.
No, you're welcome.
So can I just ask Dr.
Yes.
Lapasada, about, you said you've been involved in autopsies with dog bites.
Yes.
How many?
I've done thousands of cases, probably 50 or so. It's not always the cause of death. And then I've supervised
5.
maybe 75 more where that dog bites were involved in the case.
When was the
Please.
last one?
Let's see, probably 2 years ago.
Okay. Any questions based on my questions?
Yeah.
All right, you are all set and asked you to step down, Dr.
5.
Lapasada.
Yeah. 5
We'll
jump
get
to
you
50.
sometime
Come
this
on.
afternoon.
Thank you, Your Honor.
Come on.
I do want to give everybody a break, including counsel. Can we do less than 5-minute arguments on this?
Exactly. Yeah, 50, 75, went from 5. Mr. Jackson says 5, and then magically she says more. Isn't that funny? Professional liar.
Okay.
Is eminently qualified to speak to both the issue of wound pattern recognition as it relates to dog bites, specifically, as well as cause and manner of death as it relates to vehicle pedestrian incidents or impacts. The doctor has an incredibly impressive resume, just a touch of which we reviewed during the course of this
Oh, please.
voir dire for her qualifications. But with regard to the dog bite specifically, she talked about the differential diagnosis that she undertakes and undertook in this case. She talks about the inferential thinking that she undertook in this case. She talks about how that is the proper methodology in the scientific community and specific to the forensic pathology community in order to come to a determination about wounds and the source of wounds, i.e., was it a dog? Was it another animal? Was it another source? Was it lacerations versus abrasions, things of that nature? She's obviously done, as she indicated, thousands, if not climbing real close to 10,000 autopsies that she's either supervised or that she's conducted herself. She actually has, notably, as per the court's last question, she's actually undertaken personally.
AJ said 5
somewhere close to,
earlier.
I thought it was probably 5.
He said 5.
Autopsies herself dealing with dog bites. They're not always the cause of death, but sometimes it's attended to the injuries
Come on.
that led to a different cause of death. But she's undertaken at least 50, or that's what she estimates, 50 of those autopsies herself. She's seen dog bites. She's seen dog wounds. She engages in pattern recognition. She also teaches classes on pattern recognition as it pertains to dog bites, and she's eminently qualified to speak to that in this particular case. She has been able to come to an opinion and conclusion as to whether or not the injuries to John O'Keefe's arm are consistent or inconsistent with dog bites, and I expect that she would then give that opinion and conclusion to a reasonable degree of medical certainty and to a reasonable degree of scientific certainty. As it relates to her differential diagnosis and her ultimate conclusions concerning the automobile impact, obviously, many, many, many more autopsies dealing with that because it's more common. She also engaged in the exact same differential diagnosis. She has training. The subfield of, or the sub-issue of vehicle pedestrian impacts is included and subsumed within much of the medical literature that she's been taught on, going all the way back to the 1980s, dealing with her boards, and she's consistently passed her boards. She's consistently kept up with the literature. She's consistently engaged in autopsies herself, so she has firsthand training. She also trains other medical professionals, other doctors, other medical examiners, and she supervises other medical examiners. She's been the chief medical examiner for an entire state. I cannot imagine somebody more eminently qualified to talk about the two subjects that she's been called to talk. Well, she's called to talk about several other subjects, but these two subjects that's before the bench right now, than somebody with Dr. LaPosada's qualifications. I will submit on the voir dire that we just completed.
All right, thank you. Mr. Brennan.
I do not think that Dr. LaPosada has articulated the experience the way it's been summarized.
Nope.
She could not provide any specific training other than her boards and her references to literature. She could not articulate one single class or seminar that she took that pertained to differential diagnosis of dog bite injuries. She has no specific memory of having any type of experience in differential diagnosis as far as being in a training seminar or advanced education. She has the experience of a medical examiner who has seen what she believes to be dog bites in the past. She has no publications or references that she has studied the issue of differential diagnosis or pattern wound recognition relative to dog bites. If we look at the standard Dr. Russell employed, Dr. LaPosada does not have any of the merit to be an expert in dog bites. While she has taught, we did not hear about anything in particular that she has taught about specific pattern wound recognition analysis regarding dog bites. She is an experienced medical examiner, has a wealth of experience, past experience in autopsies, but she has no experience that is a basis for her as an expert in being a dog bite expert. Particularly, she mentions one case that she's testified in federal court that we've heard of today, and she has nothing whatsoever in her report or resume to establish that she has used, studied, and knows this methodology. In fact, her CV and her report don't have any basis for one to look at and see that she has any specific experience in dog bites. And so Dr. LaPosada, from the Commonwealth's perspective, should not be able to give an opinion regarding or about whether or not the wounds on Mr. O'Keefe were caused by a dog. She simply does not have the training and experience and education and methodology to make her a so-called dog bite expert.
Y'all killing me.
accident
I'm starving.
reconstruction,
Y'all talking about
said it
food.
best. She is not an accident reconstructionist. She saw some of the materials in this case, but it is a fraction of the materials in this case. She is not in a position to give an opinion whether or not the wounds are consistent with broken taillight. There is nothing we see on her CV. There's nothing we see in her report. There's nothing we heard on direct examination that she has any experience in breaking glass, breaking plastics, and the causation of wounds. It also overlooks the fact that the opinion that would be offered would extend beyond just the wounds on the arm. It would extend to a general opinion that he was not involved in a collision, and that's improper. There's no predicate or basis for it.
Nope.
And so based on her testimony and absence of being able to provide any education or experience, she should not be able to testify about either of these two matters.
Okay, thank you. Okay.
There is none.
Suggest that, well, she's only been qualified in one court, federal court, the federal government, the federal judge who's handling that case qualified her as a dog bite expert in that case. That is not a small thing. That, as a matter of fact, it's
It is
a
a
very
small
big
thing.
thing.
She's not a dog
For
bite
Dr.
expert.
LaPosada and her credentials. In addition, she indicated, contrary to what Mr. Brennan just suggested, she indicated that she has been training on wound pattern recognition as it pertains to dog bites for her entire career, not just when she was studying for her boards since she's been studying for her boards. And it's been constant and consistent throughout her entire career. She's made these differential diagnoses. She's seen the autopsies. She's seen the wounds during autopsies firsthand, probably 50 or more. She's supervised another 75 or more autopsies dealing with known dog bite wounds. She has the credentials. The court will recall that, for instance, Dr. Isaac Wolf was called to testify by the Commonwealth. He had absolutely nothing, no credentials whatsoever to talk about wound pattern recognitions. He was a neurosurgeon, and yet he was allowed, over Mr. Alessi's objection, to talk about and to discuss his opinions and conclusions as to the wound pattern on the back
On
of
head
Jonathan
injury,
Kent.
because he's a brain
Dr.
surgeon.
Brings much more to the table than Dr. Isaac Wolf. I'm not comparing them. They're apples and oranges. Dr. La Posada is she doesn't have to be a sole dog bite expert to be expert in dog bites. She doesn't have to be Dr. Russell. She just has to have that level of knowledge, that level of skill, that level of expertise that's beyond that of the average layperson in order to opine as an expert on a particular issue. She certainly brings that to the table as it pertains to dog bites. And I think her skill and her education, training, and background certainly speaks to the fact that she has that in spades with regard to motor vehicle pedestrian incidents.
All right. Thank you. All right, I'll get your ruling as soon as I can. So we're going to start back up at 2:20, and I expect to go straight through the rest of the afternoon.
All right, for the court, please.
2:20, dude. That's another 7 minutes. Even another half an hour? Come on, man. That's absurd. That is absurd. I'm so hungry. You guys are killing me with this. Right? 50 dog bites a day for 50 years. A Batman villain. Like, holy Batman. Holy Batman. She is not a dog bite expert, okay? Not even close. Not by a long shot. Hold on, let me mute this elevator music here, because that's what they're playing over here on Court TV is elevator music. I mean, this is so insane to me. Right? I don't mean either, because Dr. La Posada has been willing to lie quite a few times, including in other court cases. That's why she was disqualified as an accident reconstruction expert in another case that she tried to play accident reconstruction expert. So I love when she's like, nope, I don't know what you're talking about. It's funny because in another article that I put out, I showed you guys, I put it in the Discord, I put it, I think, on my Twitter. Another article talks about how she was disqualified and how, when asked about things like leaving the chief medical examiner position after not doing 1,512 autopsies, not finishing those reports, and how she took 17 hours to get to the station nightclub fire. 17 hours, numerous phone calls, and 17 hours before she showed up. To the poor guy who was there, had to stay there until she showed up. So 17 hours the guy was on scene. Okay. When they asked her about all of this, what do you think she did? Any guesses? Can't remember, she said. She was very elusive. They asked her if she was forced out of the chief medical examiner position. She wouldn't answer. So this is all the same stuff that I've seen from La Posada in other cases where she's just a bold-faced liar and has no problem doing it. The dollar signs allow her to come in, lie, be paid for it, and leave, and nothing ever happens. Right? How about we get Chloe in there and let her defend herself, you know? I mean, it was elevator music. I mean, it's so absurd. We're talking about, like, why so much emphasis on dog bites that supposedly didn't kill him? That aren't dog bites, by the way. Why so much emphasis? Is this all the defense has to pull out of their hat, is bitching and whining about dog bites that don't exist for people who are not credible, who are going to be completely... And I was right, by the way. They're saving Dr. Rentschler for last. Gee, I wonder why. Because you can't have a disaster expert like this Emmy last. You just can't. She's a freaking disaster. Hank is going to open her up with his legal scalpel and tear her to pieces because she's not credible as a witness. She has lied in the past. She's had some really shady dealings in the past. He's allowed to bring all of that into her credibility. You didn't finish 1,512 autopsy reports. And you misled the state of Rhode Island, nonetheless, about how many were unfinished to a couple hundred, she said. Well, that number was not a couple hundred. It was over 1,500. Okay. Oh, yeah. They still think that Chloe's not alive, as she literally lives on a farm, by the way, in Vermont, and has the time of her life, living her best doggy life. So I find it so funny. I do think we will get a verdict this week because Hank has a couple rebuttal witnesses that he's allowed to bring in. Of course, the defense didn't want those rebuttal witnesses. Now, why do you think that is, folks? Don't want the rebuttal witnesses because the rebuttal witnesses tear apart everything that the defense has tried to rely on when it comes to pure speculation, rank speculation. They have no shred of evidence that anybody besides Karen Reed committed this crime, and there's no room in the timeline for it. None. Karen's car backs up. Within seconds, John's phone stops moving forever. It is found on him after 6 a.m. And after Karen's car backs up, and after John's phone stops moving in the spot that he has found, the temperature of his battery on his phone goes lower and lower and lower, never moving again. And the temperature keeps going down until he is found after 6. Temperature starts going up, phone starts moving. When Karen herself tries to pull it out of his pocket, and it ends up underneath him when they move him, and Carrie picks it up and puts it in her pocket. Okay. So where in those seconds does a dog bite attack happen where John doesn't move from that? They're claiming he was moved. You heard that, right? They're claiming he was moved to the flagpole. Well, how does he move without his phone that's found on him, without the phone moving? Anyone? Anyone for 600, Alex? Anyone? No? Yeah? No? Yeah? It doesn't make sense. The evidence doesn't jive with the conspiracy theory. It just does not. You are still accelerating at 74.5% backwards. Okay. Defense is not arguing that Karen was not driving the car. They're not arguing that the car didn't go back 74.5% acceleration. They're not arguing that it wasn't at almost 24 miles an hour. Why aren't they arguing those things? Oh, they cannot argue that Karen wasn't the one driving. They can't argue that she didn't reverse at 74.5% acceleration when the data stopped. They cannot, and going up when the data stopped, okay? They cannot say it wasn't reversing at almost 24 miles an hour. Why? Because the hard data says it was. They're not arguing any of that, folks. None of it. There should be no doubt in your mind what happened here if you just look at the data. Take the noise out, take the cult out, take the echo chamber out, and look at the hard pieces of data that not even the defense are arguing didn't happen. And it's because they can't argue it didn't happen. Use your brain cells that I know all of you have. There's 871 of you currently watching this stream. Most of you on X. I know you can figure this out without having to be fed nonsensical conspiracy theories by a cult of people who only care about themselves, dollar signs, and clicks. It's not that hard to figure out. It's really not. If I only cared about dollar signs and clicks and not the people involved in this, then I wouldn't have relationships with people. Okay? I wouldn't be here right now. I wouldn't still be streaming hours and hours later. I don't even make minimum wage per hour. Ask yourself, who gains from a conspiracy theory that does not fit and who does not? And then ask yourself, why do you have people every day jumping onto this case and hanging on to it for dear life with a nonsensical conspiracy theory that does not fit with the evidence? You don't have to take my word for it. Go back and look at the evidence. Go back at the things that the defense is not even arguing. And ask yourself why. Why? I estimate that the defense will finish tomorrow. They will be done by tomorrow. As far as I know, the only people they have left, besides La Posada, is Dr. Rentschler from ARCA. Which, if I'm them, that's the one that I finish on, because he's the only one you can't take his credibility and rip it to shreds. He's decently credible, but he's not as evasive answering the questions or as blatantly a liar like Dr. Wolf. He does concede to certain things, and that's what makes him semi-credible. We'll see how he does. Because if he doesn't concede, which he did last time, to basic points, things in physics that are well-known, science, then it's going to show that he is not credible. In the first trial, he conceded to the things that, like Newton's law, mass and weight, those things matter. Okay? Let's make no mistake about why ARCA used 33 above freezing for their last test at over 24 miles an hour. That is because if it had been lowered to the 18 degrees it was outside, that taillight would have shattered even more than it did and into more pieces. It would have been easier to break. For years, the Free Kieran Reed people have been screaming that you can't break a taillight with a human arm. Well, ARCA just showed that you could. They've been screaming polycarbonate can't break into pieces. Well, we know that it can. They told people taillight was on top of the snow. It was not. It was underneath the snow, and there's videos of that. They told people that the clothes were in Proctor's car for weeks. They weren't. They were logged into evidence that day and didn't move again out of evidence until they went to the lab. The prosecution's allowed to do a rebuttal. The judge already ruled on it. They can't stop them. Dog has to have upper and lower jaw. The dog did not try to bite 4 times and not connect with upper and lower jaw. Okay? There's no dog DNA, not even a dog hair. Use your brain cells, people. It's not hard to figure out. Right? They left the phone in the snow. Right? They left it there to frame Karen. I mean, that's the stuff they would say. You're right. Like, oh, they just left it there. The problem with that is it has to move to get back into his pocket. When you pick it up, the temperature of it will go up. So since the temperature never went up and it never moved again, how'd you get it out of his pocket and how'd you put it back in his pocket without it moving? We're doing some Houdini shit over here. You know? They're spending a huge part of their defense on dog bites because they don't have anything else. The cops went into the house. That was another thing that FKR was told. The cops never went. Cops were in the house that morning. Brian and Cole Albert came down the stairs and there's cops right there in their house. They were woken up out of a dead sleep. Why didn't Brian Albert go outside? Had he gone outside, you would have said he was interrupting or tainting evidence. By the time he was woken up, John was already being taken on into the ambulance to the hospital. John had no signs of life. They also were told that there was inches of snow underneath John. That's what FKR was told. You know how many people have argued with you about that? Who says who? Says who? There was ground underneath John, and there are pictures to prove it. Ground. He was half laying in a mulch bed on the property line to where 32 and 34 are. Okay? Ground underneath him, which means that he had been there since it had just started sticking, which was around 12:30. Couldn't have been dragged out there at 2, couldn't have been dragged out there at 3, or there would not be ground underneath where he lay, folks. No, that's not rocket science. Those are not hard things to figure out that any lay person could figure out. Okay? But with all the noise that they're given on top of it, I get it. I get how they could believe nonsensical things if you're fed a bunch of bullshit, but it's your job to push past the BS. If you're going to make statements like the Alberts are so shady and the McCabe's and they all did something wrong, then you better have some evidence to support it and not just nonsensical theories that you were fed by people trying to get rich and famous. Wake up. These people feeding you this don't care about you. Don't care about your families. They don't care about the people they hurt. They care about their super chats. They care about their clicks. They care about their views. Again, I will state, since there's so many of you here, I'm not saying that creators shouldn't make money. Of course they should. It's their job. They should make money. But it goes beyond the line when you start lying for it. When you start telling people things you know to be untrue. Law tubers absolutely 100% know the things they're feeding people are false. They know that. Make no mistake about that. They know it. But they do it anyway. And they use their title as attorney so that people will believe them. Well, I'm an attorney, so I'm smarter than everyone else, and I must know what I'm talking about more than anyone else. I think if any case is proven that that's utterly false, it's this one. Okay? It's this one. Well, that's how she testifies, right? She walks out the door of the courthouse, says a bunch of stuff to the call, use that clip, so that people will believe her, and on we go. Why doesn't she just testify then? If she's willing to testify to the media, everything and anything, why doesn't she get on the stand and testify? You know, it was in his back pocket. That phone was in his back. That has been more than established. It was also, I believe, stipulated to by the defense and the prosecution. The phone was in his back pocket. No, I have to check. I'd have to check. I'll find it for you wherever the hell it is. I'll find it. I just have so many that it's going to take a minute. It's not going to be something that's going to take me one day. Well, I mean, we're talking about numerous people that think that they're, right. Jen's crime was helping. How dare she get up in the middle of a blizzard and take a phone call and help? Carrie too. I would have. If someone called me, I would have went too. And then what? Anybody who got up and was a decent person and helped someone, especially if they thought their friend was missing, now all of a sudden deserves to be harassed into oblivion because a conspiracy theory came out over a year later? I don't think so. I don't think so. Well, that's the thing. He's only supposed to be testifying to just measurements. That's it. And of course, the defense is trying to, sneak other things in. And they keep saying something about the other witness or the other private investigator or whoever it was being sick. I'm not buying that. I'm guessing none of you are either, but I'm just saying. If she broke a taillight on the driveway like she told us, where's the glass in the driveway? Every rabbit hole from Glass to Dogs to Higgins to Proctor all do zero damage to the evidence against her. And that's the thing, is look at the actual evidence, the actual pieces of evidence. And FKR's thing is, I can't trust any evidence, Proctor. The problem with that is Proctor did not handle all of the evidence. And not only that, but there are certain things that you can't fudge, like the car data, which is why her attorneys are not arguing she wasn't driving the car. They're not arguing her car backed up the way it did. They're not arguing that it backed up at 74.5% acceleration, which is exactly what Dr. Wolf read off from the text stream data in his own testimony. And he's the defense witness. Okay? Calgon, take you away. I hear you. Right? They placed it back in his back pocket? Of course not. You know what I mean? They swung Chloe at the taillight. That's the next thing you'll hear from them. They planted it all around John underneath the snow, nonetheless, underneath the snow, because it wasn't on top of the snow, it was underneath the snow. So how'd they get it underneath the snow? How did they get it underneath the snow? Welcome, Eva. Welcome. Glad you found us. Glad you found us. We're talking about Melanie Little's the same person that claimed that his hat and his belt and his shoe were all missing and no one could find them. We're talking about that same woman who pushed that insane conspiracy theory for months. Meanwhile, in trial, they're like, here's the belt and here's the hat and here's the shoe. I mean, what? What? Some of these people, I don't even bother going to look to what they have to say because they know they're lying, and that bothers me. They know they're lying. They can have all the field days they want. Hank at least gets up there and says, I made a mistake. We're talking about the defense that lies and tries to be sneaky and are going to deal with consequences when this trial is over for the things that they chose to do that they know they shouldn't have when it comes to this case. Make no mistake about that. Yeah, Proctor must have left the pig DNA, right, guys? That must be it. He left the pig DNA. The most nonsensical theory I've heard is that the pig ear is what that must be. Problem with that theory is if it's a pig's ear that a dog eats, then there'd be dog DNA on it. You absolute geniuses. But hey, what do we know, right? Well, I mean, didn't she though? Didn't she? Didn't she? While she was screaming, "Did I hit him? It's all my fault. I hit him. I hit him. I hit him. Could I have hit him? Did I hit him?" All the things that she sat there and screamed, and then all the things that she said in the interviews that just contradict each other. That's half the problem we have. Is her contradicting statements. FKR just sticks their fingers in their ears and goes, la, 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 la. If it's the truth, right, it wouldn't change. Her version of events has changed numerous times. Now it's the garage. Before it was the basement. How does FKR not have a problem with that? Remember, that's the way they explained steps was. It was the basement. Even though those steps didn't happen when they were at Fairview. Those steps happened when they were still in the vehicle. Still in the vehicle. Before they ever arrived at Fairview are when the steps happened. So, yeah, now it's the garage instead of the basement. No, that means the Commonwealth has the last word because they have rebuttal witnesses. You mean like another rebuttal? She's not going to allow other defense rebuttal witnesses. The reason she's allowing the rebuttal witnesses from the Commonwealth is because the Rule 14 violations when it came to ARCA and them using Dr. Welcher, the Commonwealth being able to use Dr. Welcher on ARCA's new testing. So I don't think she's going to allow rebuttal more from the defense. It's a remedy to what the defense caused. The remedy is to allow Dr. Welcher to testify to this, quote, new testing. And so any new testings they did or new reports, the Commonwealth has a right to rebut. And if they could not rebut it in their case in chief, because there was not enough time or they weren't given it until the end of their case in chief, then they have a right to use rebuttal witnesses as remedial. It's a remedy, They've changed from the basement to the garage because the basement, A, doesn't make any sense. We know his phone didn't go into the house. And because with the margin of error for the phone, the circle just makes it over to where the garage might be. So that's why they changed it from the basement to the garage to try to say that phone made it into the garage. Because we know it didn't make it into the basement. John never went there. So that's why they changed it, to try to make it so the phone makes it into the garage. So once again, the truth doesn't change. You don't have to change it based on anything. The truth is the truth. All of the evidence points to Karen and nobody else. Nobody else. I don't. It's not a screensaver. It's actually the court. That's what they put on the screen until they return, which is any minute now. So I have no control over it. I'm sorry. Apologize, Anna. I love you. Exactly. But zero explanation of how it gets from there to the flagpole, right? Right. Well, it doesn't matter to them as long as they can buy someone to give them, if they think that they're giving reasonable doubt to the jury. The problem is again, reasonable doubt has to be reasonable. There's no reason or evidence to suggest anything like that happened. No time for a beating for sure. In those seconds, 20 seconds, 29 seconds, 21 seconds, 30 seconds, 4 seconds. That's a damn good question. That was one that Hank asked Marie Russell. How does a dog bite using only its canine teeth without using its front incisors? He did ask. He asked to Marie Russell. She said it's possible. The carpet, right? The garage, right? Can't be the basement now. It's got to be the garage. It's got to be the garage. That must be it, right? So that whole theory about, the basement was ripped up and it must have been where the basement happened. Now that moves to the garage, except the garage was not ripped up. So interesting, huh? The carpet, the carpet that they have in temperature control that they can't afford to test, even though she's swimming in money. Right. Sure. Got it. Tell your husband I said high five, Alba. Tell him I said high five. It doesn't make sense on any level. And you're right, Jay. Jay said the beating theory doesn't make sense on many levels. But how would the people inside the house know that A, Karen wasn't coming in, and B, she wouldn't be right back from wherever she went? Bingo. There's no motive. Okay. And that's exactly why it didn't make sense to begin with. Is also, we're talking about people who are in law enforcement. You think they're just going to throw somebody out on the front lawn with their phone in their pocket and hope that they die? Just hope. Because if they regain consciousness and they wake up and they, call for help, you're ultimately screwed. Yeah, you're just going to leave him there on the front lawn and hope that he bleeds out and dies with his phone in his pocket. Yeah, that's a theory that makes sense to anyone. Come on, people. If that's a theory that you have been riding on, maybe you should take a second look at that and think to yourself, does that really make sense? No, it doesn't. There was train tracks behind the house. There's a gate that goes back to the woods where the train tracks are. Why not put him there? Nobody would have found him for days, months even. Why would you throw him on your front lawn off to the side with his phone? Make it make sense. And in seconds, it would have had to have happened in seconds, in 20 to 30 seconds ish, really around 4 seconds. So he went into the garage in 4 seconds, got beat up, got bit by a dog, and thrown out in the lawn in 4 seconds. Also, while the phone doesn't move back and forth as well. Just saying. The evidence shows that is not what happened. We know what happened based on the evidence. The evidence shows us a snapshot in time of what time that car backed up, what time his phone stopped moving, and it's seconds. Karen's car backs up at 74.5% throttle. Okay. John's phone stops moving seconds later. In the spot, he is later found. Phone temperature of the battery goes lower and lower and lower and does not go back up, and the phone does not move until they find him after 6. There is ground underneath him, folks, not snow, which means he wasn't thrown out there at 2 or 3, because there would be snow underneath him, not the ground, not the half mulch bed he was laying in. Okay, it would be snow. There's no snow underneath him. It was the ground, right? Maybe it was ninjas. Maybe Anna's right. Maybe it was ninjas. Maybe it was ninjas. I mean, hey. Judge said they'd be back at 2:20. It's 2:19. Are they ever on time? No, not really. But we can wish and we can pray. There's no motive. None. Zero motive. No motive. The Higgins motive is a joke. Okay? There's no motive for Higgins. As a matter of fact, he's not the one who contacted Karen. Karen contacted him and he kept questioning why. What do you want from me? Like, yeah, I think you're cute, but like what, are you breaking up with your boyfriend? Are you moving in with him? Like what? I don't, he's trying to figure out what exactly did she want from him. He wasn't incessantly calling her or texting her. They had a back and forth conversation a bunch of times, and that was that. So there is no motive of Higgins got jealous, and Karen herself quashed that, saying that John didn't even know they were texting. So that wouldn't have been a thing. And she doesn't see John reacting in a way that would cause a fight. She said that herself in an interview she did during the first trial. Okay. All right. I think we're coming back. Do me a favor, guys. Hit the like button. There's 898 of you. If some of you are on X, come on over to YouTube. Hit the subscribe button. We would appreciate it. Hit the like button. If you can donate to the channel, we would appreciate it. We run on donations from our viewers, and we're just a very small channel, so we're trying to keep the content going. We've been covering this a really long time. We have other cases that we've covered and other cases we're going to cover. You can do so one of a bunch of different ways. We have Venmo, Cash App, PayPal, Revolut. We have a link for those of you who want to use just credit or debit, and it's in the chat. It's also in the description of the video. It's also on the page of my YouTube channel itself. No, it's definitely not a motive for murder, nor would it ever be. Yeah, the forehead kiss, that he freaked out because of a forehead kiss, which again has that's so absurd, J-Rock said all the actual evidence has only ever pointed at one person, Karen Reed. That's not by some miracle or some insane stroke of luck by co-conspirators. Listen, 3 people cannot keep a secret for a month. You're expecting 70, 80, 40, 30, 20 even people to keep a secret for 4 years and no one's flipped and cracked? Come on now, get back to reality. If you're holding a glass or a cup or a bottle and you're standing, okay, Your arm is not going to be like this, like Arca had it. It's not going to be like this. All right. Do it yourself. Do your test yourself. If you're holding a glass and you're standing up, which way is your arm? Is your elbow bent? Bet it is, right? This is what it's going to look like. Higher or lower, depending obviously on whether you're sipping or not, or just holding, but generally your arm is going to look like this. Not like this, not like this, but like this. Okay. These are things that you can do at home to debunk some of these ridiculous, absurd theories, guys. You don't have to be Inspector Gadget to figure it out. You don't have to be Penny and the dog following Inspector Gadget to figure it out. Well, as we know, Carolyn, there are a lot of people who just want to belong to something, and I think that they think the cult is the place. It isn't. There are better things to belong to. There are actual communities that do things like critical thinking, try to figure things out together, and they might not agree on everything. I'm sure our audience does not agree on every tiny little thing when it comes to this case, but what we can generally agree on is this whole circus has hurt a lot of friggin' people. A lot of people. And to me, it's personal at this point, because not only do I have to deal with the harassment of these people for being willing to speak up and say something that I have been dealing with this entirety of this time, but my family has to deal with it, and that's not fair, nor is it right. But they do it to try to shut me up. And I think at this point, they know it'll never happen, although they keep trying. There are so many other people that have been affected by this that shouldn't have been, for simply following the evidence. I ask you to use your own brain cells and think about this case in a way where you follow the evidence and not the noise. Not the cult, not the noise, not the things people say on Twitter, because most, if not all of the things that they say is shady or messed up. Most of it is nonsense. Nonsense. Taillight found under the snow. These are all things that they said way, way in the beginning for months and months and months, close to a year, until evidence came out to show that that couldn't be true. Then they stopped saying those specific things, yet they kept going with other things. This is how they have been able to sort of sink people into this conspiracy. Go back to where you started in this. Okay? Go back to the beginning. And don't go la, la, la when Karen makes her statements, okay? Put your fingers in your ears when everything that looks bad for her, you can explain away by just saying everyone is corrupt. Now, is that a logical explanation? No, obviously not. You can't just say, Karen's the only one not lying, right? She's the only one? She's the only one not lying? Come on, guys. We know Karen has lied. That's not even a secret at this point, It's just not. Time to wake up, everyone. I know you guys can do this. I know that there's a lot of you. Maybe you came here today because the streams went down and this is the first time you're watching this stream. Cool. But I'm asking you to use your own brain and drown out the noise. Drown out the noise of the crap people say to you. The nonsensical things that don't make sense. And follow the pieces of evidence. We don't feed trolls here. So if you come here to insult, talk shit, you'll just be bounced. Don't waste your finger push-ups. This isn't the place for it. This community is a place where people can have discussions and they can also feel safe to not be insulted and be treated like a human being. You want that kind of community where people insult each other? Go back to FKR. We don't approve of that here. This is not one of those communities. Oh yeah, fluid. Just keeps moving and changing. Calling in sick was the most ridiculous thing I've ever seen. Ever. Come out of a case. I've never seen a murder defendant call in sick. Yeah, within seconds, It's been garbage nonsense, but there's people that believe it because they've been living in an echo chamber of nonsense of people online that tell them it is so that they jump into that mob mentality and say, oh, it must be so because all these people are saying it. Nope. It's just not reality. One person can say that you're sketchy and you're shady and you're bad. That then gets fed to thousands of people. Thousands of people say it again. They repeat it. They parrot it. Thousands more see it from other people and they repeat it, and so on and so forth. That's how easy something like that spreads like wildfire. And all of a sudden, someone said you were bad or, shady. So you must be because these people are saying you are. Any one of you could have been Jen McCabe, Kerry Roberts. Somebody called you, especially Kerry. Someone's missing. I need your help. And for that, she gets harassment for being a decent human being, going out in the middle of a snowstorm to try to help. I mean, hey. Well, it is insulting intelligence, but you have to remember how easy it is to jump into a mob mentality. The reason that cults are so easily made is because they repeat things. They repeat mantras. They repeat talking points, essentially. And it gets repeated and repeated and repeated and repeated and repeated until they actually believe what they're saying. And that's, if you look into the history of how, cults and how they come to be and why, that's part of the reason. No, definitely not a motive for murder. And yeah, it is a fictional story. The fictional story has changed so many times. It changes like everyone changes their underwear on a daily basis. Oh, no, she won't. Not in Framingham State Prison, she won't.
Well, back to session, you may be seated.
Here we go.
All right, I appreciate the court personnel waiting so that we could have that voir dire. It was helpful.
Never.
All right, so my rulings are very similar than they were this morning. So first of all, on the Darbert analysis regarding Dr. LaPasada being able to testify as to the dog bite wounds, I find that she is not qualified. I'm not satisfied that the Darbert requirements have been made. Specifically, not just the experience, but the reliability of the methodology she used and how it was applied. So based on that, she cannot testify to the dog wounds. And I want to take a minute to differentiate this testimony with Dr. Russell's. I found that Dr. Russell was an expert qualified to testify as to dog bite wounds, mainly from her experience in the ER, coupled with her being an ME. Dr. LaPasada does not have that experience. I found that Dr. Russell's methodology was reasonable and was sufficient, and I found that it was appropriately applied. Remember that Dr. Russell was published in the area here. So regarding pages 10 and 11, all of the text on Dr. LaPasada's report on pages 10 and 11 that start with the injuries on Mr. O'Keefe's right arm are excluded. Now moving on to the testimony regarding not being consistent with a motor vehicle strike. I find that Dr. LaPasada's opinion on these not being the result of a motor vehicle collision exceed what is within her scope of expertise in some regards, not in all. In some regards, significantly, like I said this morning. So on page 17, the first sentence is in. The second sentence, tail lights are typically made of durable polycarbonate or acrylic plastic. That is out. I know the Commonwealth objected to, but I'm letting in. Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting the arm. She cannot say tail light, but she can say that based on her experience. His arm had no tissue bruising from impact. That also comes in. And the next sentence, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. That's within her realm of expertise as a medical examiner. The next page, though, I may have said this morning that first sentence, importantly, in review of that and review of the Tompkins case, that first sentence stays out because to me, it seems like that sentence depends on a biomechanical analysis, factors such as speed and force and the position of Mr. O'Keefe. So that's, oh, I'm sorry, page 18, the next page regarding the same subject matter. And portion of the next sentence is also out. This results in bruising or bleeding under the skin. That's out. But Dr. Laposada can testify that Mr. O'Keefe had no bruising on his arms or torso. And that's it for that sentence. In particular, Mr. O'Keefe did not have bruises on his legs as shown by dissection of leg tissue and muscle at autopsy. That's it for that. And the conclusions are problematic to the extent that is consistent with this ruling and what we discussed on Friday. So that's it. That was just the text of her report. I have not begun to go through all of there's no PowerPoint with this, Mr. Jackson, right?
There is no PowerPoint.
All right. Do you intend on displaying any of these photographs?
I'm sorry.
Do you intend on displaying any of the photographs that are in her report?
Yes. I have to go through it now, of course.
All right, so you likely not get to that today. We've done important work, but we've wasted an awful lot of the jurors' time today. So I want to bring them in. And
No problem with that. My suggestion, we have to finish it anyways.
right, we're going to do that now. So that'll give you an opportunity to pull your thoughts together.
Right, and I expect what I will do is my attention. I will go through those things. That will take me a good amount of time. I will go through the part of her initial analysis that will not include any of the photos, but I may need overnight to actually go through the court's ruling. It's very specific, and I want to be as
Okay, so let
to that as possible.
let me know what you intend to put in. All right, and there's a lot of text describing the photos that is out, right? It's just hearsay.
I mean, we've had Dr. Welch's PowerPoint.
That was not objected to. There's a big difference.
Yes, it was objected to.
So
It was.
we'll deal with this tomorrow, with the photographs
I
tomorrow.
just wanted to let the court know. I'm not wasting the court's time.
Okay, thank you. And we're bringing the jurors in. Did the Commonwealth want to respond in any way?
No, thank you.
Okay. And there's a motion on Dr. Rentschler. We will give that, I haven't read it yet. We'll give that no more than 5 minutes tomorrow morning each side. The jury, you can tell just by looking at this jury, they're fed up.
I
So-
don't blame them. Wouldn't you be?
Your Honor, the only thing I want to put on record is, with regards to the court's ruling, I do want the record to reflect that is obviously, it's over the defense objection.
Sure.
And I just want to make for the record a quick comment. The Commonwealth waited until June 5th to even bring this up, to file a motion regarding Dr. Laposada. They have a report, and all reciprocal discovery was done in March 6th, 2025. That's document number 45.
Yeah.
And the Commonwealth was ordered to file whatever motions they wanted to, whatever motions in limine they thought were appropriate by March 7th. And they did not do that. They were supposed to be heard on March 18th.
Okay, so the jurors are coming in. We're going to mark the report and the CV for identification.
I just need to know when I can make it.
You just made it.
I made it-ish. I wasn't
Okay.
actually holding the record myself,
Okay.
but the point is,
Go ahead, real quick.
the Commonwealth has not explained the delay
So,
in making this motion. They haven't, and we're playing by the same rules.
so the basis of my ruling was not late disclosure. Okay? Late disclosure, disclosure. Commonwealth says they're part.
That's not the court's missing the point. It's the opposite. We got late disclosure. We got late disclosure that they were objecting. They've had since March to object. They blew the motion in one time, and then they come in just before.
Doesn't matter when they objected. They objected.
Just before Dr. Laposada testifies, and
and now we're sort of sandbagging this.
She's fed up.
So I want to look at the record.
And they're fed up. Sure.
Very clear. Mr. Brennan, do you want to respond real quickly?
Your Honor, we can always object even during proffering of testimony. There's no foundational issues.
And that's consistent with what my rulings were when I allowed other witnesses to testify, that the defense could object if the foundation weren't properly laid. So bring them in, please.
Thank you, Eva, for your $20 donation. Thank you so much. I appreciate that. Just for an excellent YouTube channel. Thank you, Eva. The jury is fed up. So basically, they're just arguing over motions. Jackson didn't like the, fact that the Commonwealth objected to something, and he says they objected to it too late. The judge doesn't agree. It's nothing serious, just Jackson bitching and whining per usual. The jury is fed up, but what I don't understand is, how does the judge not understand that they're fed up that they don't start on time? They're fed up that they leave early. They're fed up that they're given ridiculous days off and half days for no real reason other than a one time for a juror. I mean, maybe you shouldn't have given them 5 days
You have
off.
been extraordinarily patient with us today. We're going to go straight through until 4 o'clock.
Oh yeah, till
We're going to make
3:58
every effort
probably,
to
right?
not leave you waiting out there as long as you have, as long as we did today. All right, Ms. Giannetti, is your witness ready?
You guys are killing me. I'm so hungry. Those egg rolls sound so good. You ever had steak and cheese egg rolls? Those are so good too. I'm so hungry.
All right, Mr. Tedman, whenever you're ready, sir.
Thank you. Thank
I
you, Your
think they
Honor.
pop up right away. Trolls do what
Sir,
trolls do.
before the lunch break, you had identified 3 entrances to the front of 34 Fairview, leaving aside the 2 garage car doors. Do you recall that?
Yes.
May I have that last exhibit displayed, please? Not that one, the one that we discussed right before court. There it is. Maybe zoom in on that a little. Okay. What do you see on the screen at this point, sir?
I see the 2 rightmost entrances to the house, excluding the main front door.
Okay, which would be obviously to the left
To the
of this
left.
photo, particularly with regard to the 3rd entrance, the one in red. Could you describe that?
Yes, so it's if you're facing the house from the street, you're looking towards the west. So that door goes directly into the garage facing north.
Okay, so basically from the street, you don't have to enter the house, you can go into the garage directly.
That is directly into the garage, yes.
All right, and as we're looking at the house from this point, are we looking at it from the vantage point of Fairview Road?
Yes,
And that is a westerly direction toward the house, sir?
correct.
In the course of doing your further work that you were asked to do in this case, did you peer inside the garage?
Yes, I did.
Did you see concrete steps and a ridge there and a hard concrete floor?
Yes.
Sustained. Jurors disregard that answer.
You mentioned that you were asked to do some measurements. Can you describe what you were asked to do for the jury?
Yes, I was asked to measure from basically the mailbox area of the driveway to the various entrances to the house.
Did you take those measurements?
I did.
Okay, if I'd like to take them one at a time. First, did you measure from the
DoorDash.
end of the driveway next to the mailbox all the way to the main front door, which is not depicted on this photo?
Yes, I did.
How did you measure it?
I used my wheeled measuring device. And I walked directly across the lawn to the front door, well, to the bottom of the front steps, and then used it to go up the front steps straight to the door.
And what was the measurement, if you recall, from the mailbox area near the end of the driveway to the main front door on the left?
I believe it was 65 feet 9 inches, but I have notes if
I think you got it right, sir.
Okay.
Next, did you measure from that same location near the street, the end of the driveway next to the mailbox, to the second front door, which is actually depicted in the exhibit that's on the screen?
I did.
And how did you measure that?
I walked along the edge of the driveway on the asphalt right next to the grass towards the house from the mailbox and the edge of the street towards the house. I took a left onto the brick walkway, proceeded along that walkway, then took a right to the walkway that you can see right there, heading directly to the door, and went up onto the little decking area, and then those 2 steps directly to the doorstep.
Okay, so you walked essentially almost the whole length of the driveway
Yes,
before you took the left to get to where the steps start going to that second front door,
yes,
and then went up to the door itself.
yes.
Do you recall from your memory what the measurement was?
I believe it was 70 feet 1 inch.
And finally, did you measure from that same end of the driveway near the street next to the mailbox to the red side door, which is the pedestrian entrance into the garage directly?
I did.
How did you measure that?
I did the same thing, walking directly from the where the mailbox and the driveway intersect, basically, all the way up the driveway, took the same left onto the red brick pathway, took a right to go towards the front door, went up the 1 step that you can see, and then instead of going up the next 2 steps, I took a right directly towards the garage entry door.
So essentially the same path of travel, it's just you didn't go straight into the second front door. You took a right to go into the pedestrian entrance to the garage.
Correct.
And what was the measurement that you discovered having done that?
I believe it was 78 feet 3 inches.
Now, finally, could we have displayed the map of Cedar Crest, Fairview, and Chapman? There it is. Sir, are you able to see the street names from where you are? And if
Yes.
not, could we have the top street magnified so that the witness can see it? Okay, you see that?
I do.
What do you see that to be?
Cedar Crest Road.
Okay, if we could have the connecting street where the, that's it.
Fairview Road.
All right, and finally, the one down the bottom?
Chapman Street.
Okay, if we can get the whole map back up. Having seen those 3 street names, does that orient you as to what this is a map of?
It does.
And what is that?
This is the surrounding area of 34 Fairview Road, the neighborhood, basically.
Okay, and it includes the 2 connecting streets on either end?
Correct.
Does the red dot symbolize anything for you?
It looks to be where 34 Fairview Road is located.
Okay, and if you're on Fairview Road to the right of that red dot as it exists on that exhibit, and you're looking toward Fairview Road, what direction would you be facing?
It'd be facing west.
If I may have a moment, Rick?
Okay. I honestly don't think Hank's gonna cross this guy. He did measurements. Like, I don't really. I wouldn't.
Thank you very much, sir.
Thank you.
Yes.
He does have some questions. I'm shocked.
Good afternoon, sir.
Good afternoon.
You had a wheel to measure,
Correct.
and so there's like a tape measure, and when you wheel it out, it gives a straight line?
No, it's two wheels with a meter in between them, and you roll it out in front of you.
I see. Your first measurement was from the driveway to the front door,
To the main front door to the far left, yes.
and that was about 63 feet?
I believe it was 65 feet, something like that. I have
65?
my notes. Yes.
So suffice to say, if you were to leave the front door and come back to that spot, it would be an additional 65 feet back, right?
Yes.
The second measurement was from the bottom of the driveway to the middle door on the side?
Yeah, the second front door, yes.
Did you say that was about 70 feet?
It was, yes.
Okay. And again, if you were to come back, that would be an additional 70 feet?
It would.
And the last one was the door near the garage. Did you say that was further, around 80 feet?
78 feet, 3 inches, I believe.
Is it one way?
Correct.
And back is another 78 feet.
Correct.
When you measured these, was it from the asphalt of the driveway or to the left of the mailbox as you're looking at Fairview?
It was to the right of the mailbox on the asphalt, as close to the mailbox as I could get.
Did you happen to take any measurements from the flagpole to the front door as far as distance?
I did.
And what was that?
I do not have the exact measurement. I'm not sure.
Do you have it in a report that you could
I
look
don't.
at?
I don't. No, not with me.
How about the flagpole to the middle door on the side? Did you take any measurements of that?
I'm not sure I took that one.
How about the flagpole to the furthest away door, which would be the door next to the garage? Did you take any measurements of that?
I think I took a direct measurement to that, yes.
Right. What was that number?
I don't know.
Do you have a report you could share with us?
I
That
don't.
number?
No, I'm sorry.
It's okay. Did you ever measure if you were at the flagpole area, how long it would take to walk up the street? Or how far it would be to walk up the street, up the driveway to any of those doors? Did you ever measure it that way?
I did.
And what was the distance if you were going to start at the flagpole, walk up the street, up the driveway, down the walkway to the front door?
I'm not sure that distance. Not positive the distance.
Was it over 80 feet?
It was.
And if you did the same route up the street, up the driveway to the middle door, would you agree that would be well over 80 feet as well?
Can you repeat the question? How?
Sure. If we were to measure from the flagpole up the street, up the driveway to the middle door, that would be well over 80 feet.
Yes.
Same to the door next to the garage.
Yes.
Thank you for your time.
All right, nothing further.
All right, you are all set, sir. Thank you very much.
So random. And if I'm the jury, I have no idea why that was done.
Okay, Mr. Jackson.
Thank you.
At all.
I would ask the court to
La Posada.
ask Dr. Elizabeth Laposada to join us.
Okay.
La Palooza. Bless you, whoever that was in the court. Bless you. Hit the like button, folks. I'd appreciate it. If you'd like to donate to the channel, you can do so one of these ways.
So the evidence given to the court and jury in case never hearing the truth, the whole
Right?
truth,
The
and nothing
best witness. You got that right, Grave.
Good
I was
afternoon.
just talking about you a
Good
minute ago.
afternoon.
I was like, I haven't had Chinese food since that time Grave told me to go get Chinese food. We were talking about spring rolls and egg rolls.
May I
I
inquire?
missed it.
Yes.
And Dr. Laposada, please speak right into that microphone,
I
okay?
will.
Thank you.
Yeah, loud.
Doctor, can you
Wow.
please state your full name and spell your last name for the jurors?
Yes, Dr. Elizabeth Laposada, spelled Laposata.
I'm going to ask you, you have a softer voice. I'm going to ask you to pull that microphone right under your chin, if you don't mind. It's pretty adjustable.
Yeah, great.
Better?
That's better.
Okay.
That's better. Doctor, can you tell the jurors what you do for a living?
Yes, I'm a medical doctor and I subspecialize in forensic pathology.
Can you summarize your professional background?
Certainly, I graduated in 1975 from Bucknell University with a Bachelor of Science in Biology. I went to University of Maryland School of Medicine, where I graduated in 1979 with a Doctor of Medicine. I did my internship and fellowship at Johns Hopkins Hospital in Baltimore, where I studied anatomic pathology, which is the study of the diseases of the body. I then did my subspecialty fellowship in St. Louis in forensic pathology, which is understanding causes of death and injuries to the body.
Currently, are you a professor?
Yes, I am.
And tell us where you work.
I own my own independent consulting practice,
Sounds like
and I'm
Darth
also
Vader.
an associate professor at Brown University School of Medicine
How long have you taught at Brown
I am your
University School of
father.
Medicine?
since 1993.
And how long have you been a clinical associate professor of pathology either at Brown or before that?
Oh, gee, then that would have been since at least in the late 80s. I've been associate professors at the universities and medical schools where I've worked.
Doctor, at Brown University, let's take Brown first. What do you teach there?
I teach the second year medical students. I teach a lecture in diseases of the heart, cardiomyopathy, and myocarditis. And I've been asked to give some specialized lectures in toxicology and forensic pathology.
Are you responsible for training medical students in the field of forensic pathology?
When I was a chief medical examiner, yes, we would have medical students, residents come into the office so they could learn about what we do to understand cause and circumstances of death.
When you first got your medical license, did you then undertake to get certain board certifications and the like?
Yes.
Before we get to those board certifications, did you begin a practice in forensic pathology in some way or another?
After I finished my medical school and my anatomic fellowships and forensic pathology fellowships, then I was working in medical examiners' offices where I was examining deceased people to understand how they died.
When you get a medical license, is that statewide or is it nationwide?
Usually you get a state medical license.
And do you hold a state medical license?
Yes.
How many?
I have an active medical license in Rhode Island where I have my consulting practice, and I have inactive license in Maryland, Delaware, Missouri, Pennsylvania.
And you've been previously, at least before they were inactive, you were licensed in all 5 of those states?
Yes.
You already told us a little bit about your college. Did you mention Bucknell University? Your Bachelor of Science degree?
I think I did, yes.
At some point after you graduated from the University of Maryland School of Medicine, did you complete any residencies?
Yes, I did my residency at, excuse me, at Johns Hopkins Hospital in Baltimore in anatomic pathology.
Forensic pathology is different from anatomic pathology, correct?
Yes.
Did you also do any kind of residency in forensic pathology?
Yes, I did a fellowship in forensic pathology.
And what is the difference between, if you can sort of take us through that little by little, what is the difference between forensic pathology and anatomic pathology?
Anatomic pathology is sort of hospital-based pathology where we understand diseases of patients who are in the hospital and try to make clinical pathologic correlations to see if their diagnoses were correct, if the laboratory tests actually showed what we find at postmortem. And then forensic pathology deals more with understanding why the body stops functioning at a particular time. So that would be cause of death. And that can be sudden unexpected death or death due to violence.
And in forensic pathology, is that often associated with testimony in court cases that may deal with either on the civil side or the criminal side, coming in and testifying about things like cause of death and manner of death?
Yes.
What types of cases did you work on during your forensic pathology residency?
Oh, sudden unexpected natural death, gunshot wounds, knife wounds, sudden infant deaths, blunt force trauma, skeletonized remains, decomposed bodies, strangulation, the whole gamut of ways people can die unnaturally.
Thank you, Jack. To contrast that, what types of cases did you work on during your anatomic pathology residency?
Probably wasn't on the
There
Bucknell
you're mainly
team.
dealing with natural diseases and understanding heart disease or how somebody gets pneumonia, or looking at the brain to understand if a stroke was present. And that's especially important then to the doctors who are treating those patients, that they can see if the diagnostic tests were appropriate or if their treatments worked.
You mentioned fellowship a little earlier in your testimony. What is a fellowship?
A fellowship is after you've done your internship and residency. A fellowship is more specialized training, and I did that in forensic pathology.
So that answers my next question. You do hold a postgraduate fellowship position, correct?
Yes.
And that was in forensic pathology specifically?
I'm board certified in anatomic and forensic pathology.
Mr.
Well, you're a
Burns.
research associate at the Department of Pathology and Laboratory Medicine at University of Pennsylvania School of Law.
Two over
Yes.
I'm sorry,
here.
School of Medicine.
Yes.
Old habits.
Yeah.
What about postdoctoral research fellow? Were you ever a postdoctoral research fellow?
Yes, I did. I had an NIH research grant where I worked on, excuse me, how alcohol affects the heart.
Where was that?
That was at St. Louis University, and then when I was on staff at the hospital of the University of Pennsylvania in Philadelphia.
What about postdoctoral research fellow at dealing with the cardiovascular division of the Department of Medicine at Washington University?
Yes, that's where I did research on how alcohol affects the heart.
Was all this in furtherance of your broad education and training as a pathologist?
Yes.
Tell Karen how it affects the heart.
I think you indicated that you have served as a chief medical examiner in answering one of the previous questions. Can you tell me a little bit about that?
Yes, I was appointed chief medical examiner for the state of Rhode Island in 1993, where I was responsible for all unexpected, unnatural deaths or deaths that involve violence in the state of Rhode Island. So I had to supervise the office, made sure I have adequate staff, made sure my forensic pathology staff were doing a good job, made sure I had an adequate scene investigative staff. So running the whole office.
Is that the highest appointment in the OCME's office?
Yes, it is.
In that position, did you oversee every single medical examiner in the state of Rhode Island?
Yes.
Did you also hold a position as a co-chair of Child Fatality Review Committee in the state of Rhode Island?
Yes, as part of being
Also-
chief medical examiner.
Tell us a little
Now
bit about that. What
finish
was that appointment?
1,500
Well, there's
autopsy reports.
a big concern about infants who die and children who die. So those are reviewed specifically by a group of doctors from the pediatricians and also then the medical examiner's office. So we look at every child and infant death
How long did you serve as the chief medical examiner in the state of Rhode Island?
for 12 years.
How many
Starting
autopsy
when and
reports?
ending when?
Starting
Did
in
you not finish?
1993 and ending in 2005.
11.
As the
Oh,
chief
yeah.
medical examiner for Rhode Island, did you ever
2
have the
years after the
responsibility
fire.
to work on any mass disaster cases?
Unfortunately, yes.
Trying
Okay,
to get
tell
ahead
us a
of
little
it.
bit about that. If you
Tonight,
could start
fire.
with the Egypt Air issue.
17
Yes.
hours.
Excuse me, I'm so sorry. In 1999, the Egypt Air 990 took off from New York airport and it crashed off the coast of Massachusetts and 2,065 passengers died. And because of the force of the airplane going into the water, all the
2,000.
bodies were fragmented. So all the fragments were brought to my medical examiner's office. They actually vacuumed the ocean floor, and we had 2,600 some fragmented remains from that airplane crash. And that involved working with FBI, TSA to identify those individuals and understand exactly why they
TSA?
died.
What
I
was
guess
your
they didn't
role and the
exist
role
in
of your staff that you
1999.
supervised in dealing with those other government agencies, the FBI, the NTSA, other entities in terms of the fatalities that you did review as a medical examiner or the chief medical examiner of Rhode Island?
Well, I dealt with families from around the globe who had relatives on that flight. And then the FBI was looking into what may have caused the crash. The Egyptian government who owned the airplane was also there and interested in understanding what happened. And we were also, tasked with identifying everybody who was on the plane and to see if that matched the passenger manifest list. So were there people on the plane who shouldn't have been on the plane? So that sort of thing.
In terms of matching that manifest, were you the head of the department for the medical examiner's office that was responsible for trying to figure out who was on the plane and match those remains with the individuals that were on the manifest?
Yes, we made the positive forensic identifications and returned the fragmented human remains to their families.
Doctor, did you also deal with the tragic station nightclub fire.
Yes.
In what capacity did you deal with that?
Again, this was a nightclub that burned down. It burned down very rapidly with a very hot fire, and that was in Rhode Island, and there were 100 fatalities from that. So those come to the medical examiner's office. I had my investigator at the scene throughout that time of recovering the bodies, and I was charged with determining the identity and the cause of death.
Were you successful, or your staff successful, in determining the identity of most of those individuals who perished?
Yes, all of them. We worked around the clock for 3 days to get that done.
And you were the head of that task,
I
task
was.
force.
By the way,
Before you became the chief medical examiner in
exist
Rhode Island, did you previously work as a medical
1999.
examiner under
just
somebody else?
FYI.
Yes.
Tell me about that. What was your first post as a assistant medical examiner?
My first post was after I did my fellowship training in St. Louis, Missouri. I was an assistant medical examiner for the city of St. Louis.
Were you ever an assistant medical examiner in Philadelphia?
Yeah, so after St. Louis, I moved to Philadelphia, where I was on staff at the hospital of the University of Pennsylvania, and I ran the autopsy service there at the hospital, and I was also an assistant medical examiner for the city of Philadelphia. After that, I was an assistant medical examiner for the state of Delaware, and then I came to Rhode Island as I was chosen to be chief.
Gee, I wonder.
Dr. La Posada, can we put dates on that? Assistant medical examiner in St. Louis from when to when? Do you remember?
Oh my, let's see. May I look at my CV?
Sure, with the court's permission.
Yes.
Okay.
Serious? There was no TSA in 1999, did not exist until after 9/11. So I don't know how she could have worked with the TSA on that plane crash, considering they didn't freaking exist.
Yes, from 1983 to 85, I was an assistant medical examiner for the city of St. Louis.
Howard.
Then in 87 to 91, I was the assistant medical examiner for the city of Philadelphia. 91 to 93, assistant medical examiner for the state of Delaware. And then 1993 to 2005, I was chief medical examiner for the state of Rhode Island.
Thank you for that. Dr. La Posada, have you held any faculty positions as in the field of forensic pathology that qualify you as an expert in
17
this
hours.
case?
Yes, every
17 hours.
medical examiner's office I worked in, I also had faculty appointments to teach medical students and pathology residents. So I had faculty appointments at Washington University School of Medicine in St. Louis, at the Hospital University of Pennsylvania, in Philadelphia, and in Rhode Island.
Where you were pushed out of because you didn't.
Let's talk
do your
about those
job.
one at a time. Describe your teaching responsibilities at Brown Medical School, if you wouldn't mind. And that, by the way, that's from 1994 to present, correct?
93 to, well, as a medical examiner, it was 1993 to 2005. And there I would teach the medical students. We had rotations through the medical examiner's office, and also the pathology residents would rotate through the medical examiner's office, where I would teach them how to do a medical legal autopsy, how to understand the cause and manner of death, especially non-natural and traumatic deaths.
With regard to your teaching responsibilities
Yes.
specifically, are you still teaching?
I'm teaching in the cardiovascular section now, but since I'm not chief of the medical examiner's office, I obviously don't have students rotating through there anymore.
Were you a
Sean?
lecturer in the role of medical examiner? Did you do a seminar in that regard at or associated with Brown University School of Medicine?
Yes.
Probably.
Did you do some sort of a forensic pathology rotation or for pathology residents from 1994 to 1995 in that capacity as well?
Yes, we would have the pathology residents who were at the hospital studying anatomic pathology come to the medical examiner's office so they could understand the discipline of forensic pathology.
What is cardiomyopathy?
Cardiomyopathy is a muscular disease of the muscles of the heart,
And what is myocarditis?
inflammation of the heart muscle.
Did you ever teach
I
or
have
lecture on those issues?
Myocarditis.
Yes, I teach every year. I teach the second year medical students about those heart diseases.
Have you ever taught anatomy and
Inflammation,
physiology
entire
to EMTs
Yes,
or in the EMT setting?
yes.
And what about a class known as the 2-hour primer on forensic pathology?
A 2-hour
I've
primer.
taught a lot. I don't recall that particular.
How about pathology residents morning conference in 2009?
Oh, yes. I give lectures to the pathology residents at the medical school at Brown Medical School in forensic pathology.
You also mentioned that you were an adjunct professor for biomedical forensic sciences and forensic anthropology in the Department of Anatomy and Neurology. Is that a division of the graduate school, Boston University School of Medicine?
Yes, I taught in the master's program in the medical school at Boston University School of Medicine for a master's in forensic science, where I taught a 40-hour course on forensic pathology and another 40-hour course on medical legal death investigation.
Were you actually the course director in that position?
Yes.
And were you also a course director in medical legal death investigation from 2006 to 2013?
Yes.
And what about a course director in forensic toxicology from 2006 to 2012?
Correct.
Did you direct the studies in biomedical forensic sciences, GMS, from 2012 to present?
Yes.
Describe that. What is that?
The graduate medical sciences.
Correct.
Okay. Yeah, I would review and be on the board to examine projects that the students were doing to get a master's degree.
Were you also an assistant professor in the Department of Pathology and Laboratory Medicine at University of Pennsylvania School of Medicine?
Yes.
Without going into every single class that you taught, did you teach from 1987 to 1991, attending staff medical pathology?
Yes.
What is that? Just a general outline of what that teaching course was.
That's when I was at the hospital, University of Pennsylvania. I ran the autopsy service, so I taught medical students and pathology residents about autopsy practice.
I want to ask you sort of broadly, can you describe your major teaching and clinical responsibilities when you were at University of Pennsylvania School of Medicine in the field of forensic pathology? What were your main clinical and teaching positions?
Well, I ran the autopsy service there, so I taught the medical residents and medical students autopsy pathology, and I was also a assistant medical examiner there, so I taught and started the forensic fellowship in forensic pathology.
Have you ever been qualified as an expert witness in forensic and anatomic pathology in state and federal courts?
Yes.
How many times would you say you've qualified as an expert?
Over 40 years, maybe several hundred.
How about in Massachusetts?
That includes all of them.
Okay. Have you ever qualified? Let me list a couple of states. In Massachusetts?
Yes.
California?
Yes.
Connecticut?
Yes.
Delaware?
Yes.
Florida?
Yes.
Illinois?
Yes.
Maryland?
Yes.
Minnesota?
Yes.
Missouri?
Yes.
New York?
Yes.
Pennsylvania?
Yes.
Rhode Island?
Rhode
Why so
Island,
many
yes.
places,
If I left
Roberta?
anything out, that's
Did
just
you
about
say
all.
Massachusetts?
I did.
Okay,
Not
I
even
you're
restarted with
fine.
Massachusetts.
Okay, you're fine.
Maybe 4 starter places? Maybe.
What types of topics have you qualified to testify about as an expert forensic and anatomic pathologist?
Really, anything that has to do with circumstances and cause of death. So it doesn't really matter, like, what type of injury or a sudden unexpected death. Usually it involves examination, study of information from the scene, information from the autopsy, police and investigation and medical records. And we put that all together and figure out the circumstances as to how someone died and why their body stopped functioning. So that's the basis of forensic pathology.
Dr. Williams, excuse me for just a second. You're on a mute approach for one.
I'm like an overweight cat. You're going to ask me about the jug, right? You're going to throw Alaska in there and I mean, you have to ask yourself, why so many states? I could see in your career 1, 2, even 3, maybe 4, but we're talking why so many states? I'll tell you why, because she was forced out of a lot of her positions because she didn't do the job well. It's really unfortunate, but it's the truth. She didn't do her job well. She doesn't like to do reports. She doesn't like to pay attention to detail. That's been an over again problem with Dr. La Posada in many, many instances. This is sidebar number 7. I know I'm talking through it. 5, 6, 7, but this is number 7. I don't know. I'm not even sure why we went to sidebar. It must be something that he wants to talk about that the judge still hasn't ruled on. I think she said something about dealing with it tomorrow, but I'm guessing it came up now. This was about qualifying to testify. She said all the states. Yeah. I mean, here's the thing. She was disqualified from testifying as a accident reconstructionist because she's not an accident reconstructionist. Yet they still tried to qualify her as one. So for her to pretend like she didn't know that happened, that is a theme with her when it comes to other trials and people calling her out on the things that she's done wrong, or her credibility is her saying she can't remember, or her trying to downplay it in some way, or actually at one point just being elusive and not refusing to answer. So, you know, me too, Whitney. Me freaking too. Very winded. I mean, I feel like somebody's got to get her an O2 tank. Like, you know, swiper no swiping, but they're going to have to swipe one from one of the other decrepit Reed family members. You know, maybe Mr. Burns has one in his pocket. Maybe Smithers can go run out and grab one. Something. I don't know. She might not make it to tomorrow. And make no mistake, we're probably not getting Brennan's questioning today. That probably won't happen until tomorrow. Unless Alan Jackson hurries the F up, you know? Oh, yeah, she definitely did, Mama Bree. You are right, my friend. You are right. She might not make it till tomorrow. She might need to bring an O2 tank with her because I can't. She sounds like Darth Vader. Luke, you are the father. Like, what the hell? What in the actual hell? Yes, it was number 7. Here they come.
2 minutes.
No, she's not a biomedical
I'm going
engineer.
to ask you to step down and you can go back with the court officer into that back room.
Okay, certainly.
Uh-oh.
Are
they gonna end it?
Downstairs and back up the stairs to come back in 5 minutes. I'm gonna sit here, you all can sit here, we're just gonna be in recess for 5 minutes while we sit.
Wait, what is happening right now? I'm not sure what's going on. I've never seen anything like this. They take her out of the room. They bring her downstairs, right? I feel like I could still hear her breathe. Come on. Come on. Like, I mean, they could have let her bring, my grandmother had COPD and she would get really winded, but they could have had her move the mic, you know, enough away so that it wasn't like catching her, you know, listen, I can't even climb a set of stairs without huffing and puffing. So make no mistake about it. I huff and puff too when I'm exerted. That's for sure. And, you know, my grandmother had COPD, so maybe that's what she's got going on, but it is distracting AF, bro. Distracting AF. Well, it's not her looks. It's the breathing that we all have to listen to. It's nothing to do with her looks. It's the breathing that we all have to listen to, which is highly distracting. I feel like this is why they need, like, you know, lapel mics. Something. They need something. Like, I don't understand why they sent her out of the room. For what is happening? Like, what is happening? This is crazy, Deb.
You can have a
Send her out of the room for 5 minutes with the court officer back up. I'm so confused as to what is happening. Did you need her to grab paperwork? I know they have waters there. They could have given her water. That can't be it. Like, paperwork, I'm guessing? Something they told her she could talk about or not talk about? I don't know. If I was the jury, I'd be freaking annoyed too.
You mentioned
Yeah.
several topics about which you testified.
Like, turn it.
As an expert.
You know?
I'm sorry, testified about it as an expert in several different states, several different courtrooms. Have you been qualified as an expert by those courts? in those topics about which you just discussed.
Yes.
Do you hold any specialty certifications in the field of forensic pathology?
Well, I'm board certified in forensic pathology.
What about the American Board of Pathology?
Yes, the American Board of Pathology puts forth examinations that are a 2-day examination in the various disciplines of pathology. And if you successfully complete those examinations, then you become a diplomat of the American Board of Pathology in whichever subspecialty you're in. And I became a diplomat in the subspecialty of anatomic and forensic pathology.
What about a certification in basic blood stain pattern analysis, the International Association of Identification?
Yes, I had a week-long course in understanding blood pattern analysis.
Can you tell us a little bit about the National Registry Emergency Medical Technician certification that you hold?
Yes, I took training to become an EMT.
Have you received a number of honors and awards in the field of forensic pathology?
I have.
What do those awards include?
May I look at my CV again? Sure. Thank you. I had teaching awards from Brown University School of Medicine. I was featured in a book by Faces of Public Health as having run a good medical examiner's office. I was
before the scandal?
Nominated for Woman of the Year in Rhode Island for my work as chief medical examiner and improving the office and handling those 2 mass disasters. I was honored by Victims' Rights and Services Awards because I've always been
honored for the station.
Aware of the fact that as a forensic pathologist, I'm the last doctor this person is going to have. So I try to help the family understand what happened. I was honored for my work in the mass disaster in Egypt Air 990 plane crash. Let's see. I was Outstanding Woman in Public Service for Providence, Rhode Island. I've gotten teaching awards from Brown University School of Medicine. I was elected to the Board of Trustees in the Delaware SIDS Foundation and the Philadelphia SIDS Foundation. And then we're back to my medical school.
And you, Carolyn, I'm in the room
a little
with you.
closer to your chin.
No, please don't. Oh, God.
Oh, the chair doesn't move.
Oh,
Okay.
I got it. I moved.
We'll make do.
Okay.
Thank you, Dr. LaPosada. What is the American Academy of Forensic Sciences?
That's one of our medical associations that is specific to forensic sciences.
Have you ever held a chaired position there?
Yes.
What position was that?
I was voted into a fellowship position.
Were you the chairman of Forensic Science Research, the Forensic Science Research Committee?
Yes.
What's the National Association of Medical Examiners?
It's also called NAME. It's another international association of forensic pathologists.
Were you a member of that organization?
Yes.
And at some point, did you get elected to the board of directors for that organization?
Yes.
And ultimately, did you become a fellow for that organization?
I did.
What is the American Society of Clinical Pathologists?
That's a society that is for people who practice anatomic pathology and understand how to interpret laboratory results and biopsies.
Did you become a fellow in 1991 until present for that organization?
Yes.
What's the difference between a member and a fellow?
A member is a lower level, and then you can be promoted to fellow if the board of directors feels that you've contributed in your field.
And were you associated with the College of American Pathologists?
Yes.
Are you a fellow there as well?
Yes.
What about the World Association for Medical Law?
Yes.
What about the American Association for Clinical Chemistry?
Yes, I'm a member.
Rhode Island Medical Women's Association, what is that?
Well, it's basically what it says. It's women doctors in Rhode Island.
Were you elected to the board of directors for that organization?
Yes,
Ultimately, were you elected as the president of that organization?
I was.
Rhode Island Medical Society, what is that?
It's an organization of doctors who practice in Rhode Island.
Are you a council member there?
Yes,
And what about the Massachusetts Medical Legal Society?
yes, I was a member there. They have disbanded since.
It doesn't exist anymore?
No,
When it was up and running, you were a member in good standing?
yes,
Good, good. Pennsylvania Association of Pathologists, what about that?
yes. When I practiced in Pennsylvania, I was a member of that organization.
Did you, in addition to be a member there, did you also hold a chaired position? Were you the chairman for the Committee on Forensic Pathology?
Yes,
Have you served on any editorial boards of any scholarly journals or
Yes.
publications? Tell me
Yes.
about that.
I've reviewed articles submitted for the Journal of Forensic Sciences and the National Association of Medical Examiner Journals.
Did you also hold an editorial position for the American Journal of Forensic Medicine and Pathology?
Yes,
Is that one of the medical journals that is used throughout the country by other medical professionals, other medical examiners?
yes,
It's a resource
yes,
and a text.
correct.
Have you authored any peer-reviewed publications in the field of forensic pathology?
Yes, I have.
Can you tell us about some of those publications?
Let's see if I got here. Yeah, I've written chapters in textbooks about medical legal death investigation and forensic pathology. I've published articles involving alcohol metabolism, some drugs, cocaine. Let's see. Alcohol metabolism in the heart, I mentioned. Let's see. And so I published 22 papers, and I've written several chapters.
You already said that you're board certified, double board certified in anatomic and forensic pathology. Is that correct?
Yes.
Now that you've gone through your education, training, background, publications, teaching positions, and chairs that you've held, I want to ask you a really simple question. What does a forensic pathologist do?
Yeah. We are the last doctor that the dead person has, and we figure out what happened to the body to cause their death. And we sign the death certificate that says how the body came to die and also indicates the circumstances under which the death occurred.
Are medical examiners also tasked with determining both manner and cause, not just one or the other?
Both, yes.
What is the manner of death and how is it distinguished from the cause of death?
The cause of death is what happens to the body to cause it to stop functioning. And the manner of death refers to circumstances under which the death occurred. So there's hundreds of thousands of causes of death or why the body stops functioning, but there's only a few manners of death, which would be natural, accident, suicide, homicide, or undetermined.
Those five main categories of manner of death, is that the responsibility or one of the responsibilities of a forensic medical examiner to determine that the death fits into one of those five categories?
Correct.
What does it mean when the death is deemed undetermined?
Now, when the manner of death is undetermined, that means at the time the death certificate was signed, there was not enough information to put it into either accident, natural suicide, or homicide. So at the time the death certificate was signed, there was not enough information to put it into one of those other categories. It doesn't mean that if more investigation takes place, then you might be able to put it in one of those other categories.
If a manner of death is deemed at a particular time undetermined, at that time, it's because it lacks sufficient additional information. Is that correct?
Sustained.
What types of information does a medical examiner, forensic pathologist consider in making these determinations between natural accident, homicide, suicide, undetermined?
Well, first you have the findings from the examination of the body. So that's sort of a starting place to see what happened to the body. Then you need to also look at the scene investigation. You need to look at any police reports and witness statements, and also medical history of the deceased. And using those 4 sources of information, and using your training and experience, you can either say this is a natural death, this is a self-inflicted death, it's a suicide, it's an accidental death, it's a homicide, or if all that information doesn't allow you to put to a reasonable degree of medical certainty into any one of those categories, then you have to leave the manner undetermined. And if more information becomes available later, then you can change that death certificate.
What if no more information comes available later?
It just stays as undetermined. There are cases where there's just not enough information to put it in one of those other categories.
Without getting into what they may be, did you reach any opinions and conclusions in connection with this case?
Yes.
What materials and information did you consider in reaching your opinions and conclusions in this particular case?
Yes. I have my list of materials I reviewed. I reviewed Mr. O'Keefe's autopsy report, the report of the examination of his brain, the toxicology report, and the entire medical examiner file. I studied 100 and some autopsy photos, including photographs of the brain, and then there were 70 other photographs at autopsy taken by a state trooper who was at the examination. I reviewed Mr. O'Keefe's medical records from Good Samaritan Medical Center and the EMS run sheet. I reviewed photographs of Mr. O'Keefe's clothes that were taken at the crime lab. I reviewed photographs of pieces of tail light, hard plastic, clear, black, red. I reviewed photographs of the outside of Karen Reed's SUV. I reviewed the Canton Police Department incident report on the death. I reviewed 100 and some photographs taken by Canton Police of the outside of the house at 34 Fairview Road in Canton. I reviewed some photographs taken by the real estate agent who was going to sell the house of the inside.
In total, putting them in categories, did you review the forensic autopsy?
Yes.
Did you review all of the files associated with the medical examiner's office in this particular case related to the autopsy of John O'Keefe?
Yes.
Did you review the scene investigation through police reports and other things?
Yes.
Photographs as well?
Yes.
Did you review the police reports that were associated with the initial investigation in this case as well as follow-ups?
Yes.
Did you review witness statements and things of that sort?
Yes, if they were included in the police report.
That was my next question. Those witness statements would be included in the police reports that you otherwise reviewed, correct?
Yes.
What about Mr. O'Keefe's medical history as much as you had of it?
Yes, I reviewed his medical history.
And what about hospital records?
His medical history was in the hospital records.
Understood. What method did you use or methodology did you use in forming the opinion that we'll get to in just a few minutes?
Well, in order to arrive at a conclusion of how somebody dies and what the cause of death is, we have to put all our facts out, and then we say, how could these facts have come to be? So it's called like a differential diagnosis. So like if you go to your doctor and you have a white blood cell count, then the doctor would say, well, how many ways do you get this white blood cell count? So that's a differential diagnosis. And then you go from that list and pare it down by getting more data till you come to one final diagnosis. So that's the process of determining how somebody dies and the circumstance around it.
Is it fair to say that you have a pretty significant background, training, and experience regarding coming to the conclusion of cause and manner of death?
40 plus years.
And how many autopsies in total?
Well, myself, I've probably done over 3,000. And then I have observed and reviewed maybe 7,000 more.
So that's in total over 10,000 autopsies if you were to estimate over 40 years?
Probably.
In addition to just autopsies, how many death investigations, separate and apart from autopsies, have you been involved with?
Well, the autopsy usually has a corresponding death investigation with it.
Do you have experience in examining, identifying wounds, not necessarily the cause and manner of death, but wounds that are associated with someone on whom you're performing an autopsy or you're supervising an autopsy?
Yeah, so looking at the injuries on the body and understanding what caused them is a huge part of forensic pathology.
Have you ever conducted or overseen any autopsies of individuals involved in vehicle-pedestrian collisions?
Yes.
How many times, if you had to estimate?
No, hundreds.
100 or hundreds?
Hundreds.
When was it that you first started training on the issue of wound pattern recognition that helps assist you with coming to your conclusions, whether it be auto pedestrian incidents or otherwise?
Yeah, well, understanding wound patterns and injuries is a big part of forensic pathology because we want to identify what caused a particular pattern. So understanding that whole complex bag of injuries begins when you start your forensic pathology training, which was when I started back in '81.
In addition to the cause of death, which might be whatever, a gunshot, something, does the pathologist also undertake an examination of the rest of the body that's not so obvious, other wounds, et cetera, that might tell a more defined story?
Yes, we look at the entire body, we look at the clothing, we look at the outside of the body, then we do the internal examination in order to understand not only why the body stopped functioning, which is the cause of death, but also things that could have contributed to it or helped to understand the circumstances around how that death occurred.
When you say the body, you mentioned the clothing. Why is the clothing important? Is that part of the body for a forensic medical examiner?
Oh, yes, it is. You always have to look at the clothing because it has materials on it that may be important as to how injuries occurred. So it's every time you do an autopsy, you have to always make sure you have the clothing. Many times it would have been taken off at the hospital, but then I would always ask my staff, tell the police, we've got to get the clothes, have to look at the clothes.
What is a gross examination?
A gross examination is not actually like gross, grotesque, but it means like without microscopes. It means just looking with your naked eye.
Is it important to look at a body, a deceased person, when you're conducting an autopsy from head to toe for outside obvious wounds that you can see on the gross anatomy outside?
Oh, yes, and also to collect any trace evidence that may be present on the body.
Are forensic medical examiners trained to do that?
Oh, yes.
Are you trained to do that?
Absolutely.
In addition to a gross examination on the outside of the body, is it also important to look on the inside of the body?
Yes.
Are there wounds and injuries that might be hidden by the dermis, for instance, the skin, that might not be so obvious on a gross examination of a body?
Yes, you have to look inside the body.
And what's the mechanism of doing that?
Excuse me. We make surgical incisions in the body so we can examine the brain, the neck, all the organs in the chest, all the organs in the abdomen. And depending on the case, we may make incisions in the arms and legs to look for evidence of injuries.
What about x-rays? Are x-rays an important part of an examination in an autopsy?
Yes, they're usually done before the autopsy is started, and we look for changes in the bones or any foreign material that might be present in the body, like a bullet.
Dr. LaPosada, have you ever exercised wound pattern recognition in your position as a forensic pathologist? Or do you do it every time?
Oh, all the time.
Have you ever taught any courses or given lectures on wound identification and wound pattern recognition?
Yes, it's part of understanding blunt force trauma, sharp force trauma, gunshot wounds. They all make injury patterns on the body that the pathologist can then relate to what caused that injury.
With regard to the case that's before us, what injuries did you observe with regard to Mr. O'Keefe's head specifically?
I observed that he had evidence of blunt force trauma to the back of his head.
Are those injuries consistent with a particular type or pattern of patterned injury?
Yes.
Describe that for us, please.
There in the back of his head, a little bit to the right-hand side, was a horizontal tearing of the scalp, and that's called a laceration. And surrounding that were linear scrapes that were vertical in orientation. So that is an injury pattern. And then you have to think, well, what could cause that injury pattern? And so then you go from there.
Did you also, in addition to looking at, by the way, how did you make that assessment about the injury? Was it photographs?
Yes.
Is that a normal way for a forensic pathologist to make an assessment? Is that an acceptable methodology to make an assessment of a wound pattern by the use of anatomical photographs?
Oh, absolutely.
Have you done it before?
Oh, hundreds of times.
What is a coup contra coup injury?
Now, it's a very interesting, peculiar injury to the head. When you have a blow to the head, the blow can either be the stationary head and there's a blow to it, or you can have the head that's moving and gets the blow. So looking at a pattern of coup contra coup helps the forensic pathologist differentiate that. A coup contra coup injury examines the coup, which is where the impact occurred, and then we look at what's 180 degrees opposite that impact, and that's called the contra coup, or like opposite the coup. And that injury pattern helps us determine whether a person was just having a fixed head and somebody hit it, or whether the head was just standing and went down to the ground. The coup contra coup of a falling or being pushed backward has injury patterns where the impact occurred, but then there's also injury patterns 180 degrees opposite from that. And that happens because the brain is floating in cerebral spinal fluid. And when the head comes down, the brain is a little bit behind. So you get the bang on the back of the head, but then because the brain is floating, it hits the inside of the opposite side of the head. And so that makes the contra coup pattern. And that tells us that there's been a fall backwards and hitting the head.
Is that consistent, a coup contra, just in general, a coup contra coup injury, consistent with a linear acceleration of the head by a fall, an unbroken fall straight back?
Correct. There's also some angular force in that as well.
Understood. In order to determine whether or not Mr. O'Keefe suffered from a coup contra coup injury, can that be done by a gross examination, or does it have to be surgical?
We would look at, well, first we look at the outside, but then we have to look at injuries to the scalp, and we look at the skull, see where the skull fractures are, and in particular to look at the brain and see where the damage is to the brain. And there should, in a fall backwards, you have damage to the brain at the site of impact, but you also have damage to the brain 180 degrees opposite from that. And that tells you it's a fall backwards.
In the case before us, dealing with John O'Keefe, were you able to look at the scalp and the injuries associated with the scalp from a gross perspective?
Yes.
Were you also able to look at the skull and possible fractures that Mr. O'Keefe suffered on his skull?
Yes.
And what about the brain? Did you have evidence of a dissection such that you could see the brain and determine whether or not there was a coup contra coup injury associated with the brain?
Yes, I had a full examination of the brain available.
Were Mr. O'Keefe's head injuries consistent with a coup contra coup injury?
Yes.
Could you describe that, specifically his head injuries, to the jurors, please?
Well, as we say, he has a pattern head injury on the back of his scalp, where there is a tearing of the scalp, and then vertically above that, there is some little areas of scraping to the skin. So that tells me that Mr. O'Keefe went backwards onto something that had a little ridge, but it also had some irregularity to it to cause the different scrapes before you get to the tearing of the scalp. Then when we look at the skull, he had a massive skull fractures that originated, started in the back of his head. They came around to the front. They went under the base of his brain, under the skull, under the base of the brain, and it came into the front of the skull at the orbital plates and fractured that, and that caused some bleeding in his upper eyelids. When the brain was examined inside the brain, I could see that the brain had become swollen and parts of it had herniated or moved down the area where the spinal cord is, and that's called brainstem herniation, and that is why the brain stops functioning and why your body stops functioning when you have a severe head injury.
You indicated that the wound pattern suggested a ridge or ledged surface.
Yes.
Could you explain that in more detail, please?
Yes. So if I were looking at it, I would see the break in the scalp. Then I would see several sort of irregularly placed scrapes of the skin that kind of look like pencil marks. And so that means that something with granularity he hit first, then it moved up a little, broke the scalp, and then moved on a little bit above that.
Would you expect to see that if Mr. O'Keefe had fallen backward onto a perfectly flat surface?
No, it has to be a surface that has some small ridges in it to make those little vertical patterns.
In like a berm,
Dr.
and also
Lampasado,
no.
what is ecchymosis?
Ecchymosis is a medical term for bruise.
Did you see any ecchymosis on Mr. O'Keefe that he suffered as a result of the coup contra coup injury to the back of his head?
He had a bruise on his brain at the back of the brain and at the front of the brain.
What would the outer, let me rephrase that.
Yeah.
What would you see around his eyes regarding ecchymosis?
Yes, when you have, when the brain slaps forcefully against the base of the skull, the delicate bones above the eye break. And that's, again, the coup contra coup, where the brain slaps forward. And when those delicate bones are broken, there's bleeding, and that bleeding then goes right down into the upper eyelids. So it kind of looks like you have black eyes, but there's not been any punch to the face. It's only come from the skull fracture. That's sometimes called raccoon eyes because you look like a little raccoon.
Did you see any skin injury to either one of Mr. O'Keefe's upper eyelids?
Yes, he had a small kind of slit-like defect horizontal on his right upper eyelid.
Would the ecchymosis on its own produce that type of injury, that laceration over his right eye?
No, the blood seeping down into his upper eyelids was from the skull fractures.
Was the laceration above his eyelid on the right side a separate injury altogether?
Yes, it was.
Based on your training experience, do you have an opinion as to whether or not what that eyelid laceration might be consistent with?
Some application of force which broke the skin.
Could that be from an object?
Possible,
Could it be from a fist?
possible.
Sustain us to the floor, Mr. Jackson.
Give me some possibilities of what might cause that laceration above his right eyelid.
So it's not possibilities.
Give me, in your opinion, what you believe could have caused or produced the injury to the upper right eyelid.
So I'm going to see you at sidebar here.
She needs a scientific degree of certainty, a reasonable degree of scientific certainty, not what it could be, not what the possibilities are. Come on, man. Like, this is number 8, of course, on the sidebars. But that's what the judge is getting at, is get to the possibilities, sir. That's called deja vu, Carolyn. When you feel like you've seen this before, it's called deja vu. I mean, they want her to just basically say their theory. That's what they want her to do. The problem with that is she's a medical. I don't know if I would go so far as call her a medical professional, because a lot of the things she's done has been completely unprofessional, and Hank's going to completely destroy. The reason they took almost an hour on her credentials this morning is because, you know, a lot of them, she's going to have some questions about, like, why you took 17 hours to show up at a mass casualty fire when you were called numerous times to show up there and you didn't. And that's been a question she gets almost every time she has to testify. And she likes to try to evade the question. She was never recognized for anything to do with that fire, because she misled the state about the autopsies and didn't show up for 17 hours.
May I inquire?
Yes.
Thank you. Dr. LaPosada, you just mentioned that the laceration above the right eyelid was consistent with the application of force, correct?
Correct.
You said it could come from some object, is that right?
Correct. It was fairly small. Could be, it's some sort of object.
Is it also consistent with a fist?
Sure, a fist is an object.
Okay. Your Honor, at this point, I hate to do this again. May we approach? This is probably a good time. We talked about it at sidebar.
Can you do anything to fill up the jury's time for the next 10 minutes, and then we can do this?
Not without what we discussed at sidebar.
Then why did you just come back?
Come on up for a minute, okay? Both of you, come on up quickly.
Yeah, just you sit the F down, Karen. Sit the hell down. Nope, as she gets up and as everyone she gets up anyway. It's so absurd. Like, and then they all go. So here we go. Number 9, folks. You said 1 minute, so I'm not playing the sidebar thing. I mean, I'm hungry. Screw Bev, dude. I'm starving like a hostage over here. At least she got to eat lunch and have a break. Like, she remember that a lot of us waiting for justice don't have the same, opportunities that she does.
I'm told that we're still on track.
Oh, of course.
We will start. I'm going to have you show up a half hour later than we normally do, because I expect to have 10 minutes with the lawyers, but you see sometimes with 10 minutes naturally in the course of any case can turn into. So I don't want you to be waiting as much as you've waited. So if you've taken half an hour more to get in here, whatever time you normally meet, the court officers will tell you. We'll see you tomorrow morning. Tomorrow will be a full day, and we will make every effort that it's filled with as much time here in court.
To not have
sidebar conferences
10
without
sidebars?
Delays for us to have hearings. So tomorrow, plan on a full day. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. If you Careful again with your social media use. I'll see it tomorrow. So Dr. Wapasadi,
Yes.
you can step right out, you just follow the jury, and we'll see you
Okay.
tomorrow night. If you're here, make sure you're ready to go at 9.
I'll be here.
She
Thank you,
always
Your
says
Honor.
that. I had a schedule. I had a schedule. I just don't believe that. I don't know. I don't know if she's just saying like that they're making the jury leave so they don't have to continue to be doing it at Sidebar. I don't know. This is just absurd. Per usual. Oh yeah, she's calling it a day for at least the jurors. Seems like they have something to do. I don't know. We're gonna find out in a second. Right? It's not going to be finished early. There's nothing here that's on, you know, early, or I mean, you could have already finished this.
All right,
This trial could already be
so
done.
can you argue the Commonwealth's motion that I received this morning regarding Dr. Renshaw? Can we just do that now?
Let's do it. Exactly. No such thing as
Okay.
a head of schedule for a goddamn jury.
No,
They just want to
that's
go.
fine. So we'll do that first thing at 9 o'clock tomorrow morning. The
Oh,
basis of the
God.
Commonwealth's, I've read the motion. I think the motion is clear. I'll hear you both tomorrow on it. All right. And you'll take
Nope,
care
never.
of the photographs, whatever photographs in her report you intend to put in.
So is the court hasn't made a order yet, but it seemed like the court was leaning toward not allowing any text on the photographs.
So that was just at a quick review. I had not I just read the content, the text part for the arguments for today, the arguments that were brought up today. I wasn't anticipating everything that we heard today on this, so it took a while. I did not get to look at specifically those. But to the extent that it's hearsay, whether it considers anything about dogs, clearly the dog, things that have been excluded have to come out of the photographs. All right.
The other photos deal with gastric mucosa.
I think those have been shown, and I know the Wisniewski spots one is in evidence. The brain photographs are not coming in. The brain photographs that are different than what's already, the brain photographs in her report.
Understood.
They're-
My biggest issue is the stomach lining is a bigger issue, and some photographs do like the car is probably already in, things of that nature.
So tell me what you think is more of an issue, more of what you want. So I don't think the photographs on pages 4 or 5 come in. They don't add anything and they are extremely inflammatory.
I'm not,
Mhm.
I'm not looking to get those.
All right, the photos on page 6, I believe, are already in evidence. So this is,
That's a Lucas machine.
right, just a textbook photo of a Lucas machine.
Correct.
Is there an objection to that, Mr. Brennan?
No, thank you.
Okay. So do you want all of that in or just the photograph that's got color to it?
I'd actually like all
No, it's about the same length as the first trial, but it should have been a lot quicker because there's less people.
Send it to the Wisniewski spots for that.
Okay.
First trial took 9 weeks.
Page 14, I think these are all in evidence otherwise, but I would like this particular, it's all in one spot.
Hold on 1 second. Okay, so 1 is in. Point number 1, that was in evidence, and those 2 photographs, this is all
Exactly.
for number 1. What was,
These are all close-ups of the same photo that is already in evidence.
okay.
Right. So I would like to use this because it speaks to her evaluation of these particular.
All right, how does she know it's blood staining on the fabric around the puncture? I'm just curious.
Yep.
The blood stain on fabric around the puncture.
Yes.
I'm assuming she's getting that from the lab. They tested it.
Okay,
Lucas
I don't recall testimony regarding, doesn't mean it didn't happen, I just don't recall it, so I just need to know
Lucas
the source.
machine.
All right,
It's not the breathing machine.
I have no objections to the photos, I do have an objection. Yeah.
okay. 13A and
9?
13B?
I think it was 7 to 9.
Yep, so 13B's out because of the dog bite. Let me see. All right. So if we keep out the blood staining, Mr. Brennan, is there an objection? Oh, puncture. What's the objection for the Commonwealth on 13A?
The opinion outward tearing. The opinion
Yeah,
blood-
exactly. 8 to 9, 7 to 9, something around that.
Blood stain coming out, outward tearing that is her opinion of what it looks like.
Okay, so we're going to have to see if she's qualified to do that, to testify to that. All right. What's the next page?
Page figure 3 in the report.
What page?
Don't have page
Thank
number.
you, Mrs. 101. Yeah,
Page 5.
Page 5. It shows the cross section of the brainstem.
That's what I was saying. I didn't see how.
I'm gonna argue that the machine could or couldn't make certain spots on the lungs, blah, 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 blah.
This is no more graphic than the side.
At least that's what they argued before,
I
I
disagree,
believe.
but why does she have to use this photograph?
It furthers her determination of the constitutional injury. It supports that. I didn't put it in during that conversation.
Okay.
But
There's no contention that coup contra coup is the cause of the brain injury, correct?
there is a contention that the coup contra coup is. Yes, that is the contention. I don't think there's any controversy.
Oh, my God.
I thought that's what Dr. Wolf testified to, no?
Consistent. I don't think there's any disagreement.
Right. So I don't know why we need this photograph.
Because this shows, at least for her, this shows a bleeding of the.
No, there is no law that says that can't stop. Task for Massachusetts just loves to stop it
Okay.
for.
No, I understand that's an issue.
Some will go to 6 o'clock.
Okay.
The judge, it's really mostly the judge, and she doesn't like to go not a minute past 4, you know?
What else, Mr. Jackson?
I think you've seen this, Your Honor, and I'm looking at figure 5. So there's these spots.
Yeah, I think that's already in evidence, isn't it?
I mean, regular CPR can break and crack your ribs if you're giving regular CPR. If you're doing it correctly, you could break some ribs for sure.
I recall it was up, and I usually don't put up chalks, but okay.
I have updates I'll give them to you guys in a second.
Excuse me?
Mr. Lessie. Can you say it again? Thanks.
There's only one person who can talk at a time. I'm told it's Exhibit 164.
Yes, Your Honor, my understanding is it's marked as an exhibit only. It was used as a charge, but not in evidence.
Okay, so if it's marked as an exhibit, it means it's in evidence.
You dumbass.
I'm told I think it's an exhibit. We can find out. If it's an exhibit, everybody's fine with it. It's in.
Right, it's already in. What do you mean?
164, I think. We'll know. Okay, what are those?
Like, what the hell?
All right, so we'll have to see what's in and what's not. I'm just trying to make the best use of the time here.
The next is figure 9.
You're welcome.
Send it to these 2 photographs. Send it to the Redux machine.
So you're saying 9 in evidence or 9 on the form?
Right.
9A and B. Is there an objection to these, Mr. Brennan? Going to the Lucas compression device. There's one on someone who's not John O'Keefe, and then this is on Mr. O'Keefe.
No objection.
Okay, so those will come in.
That's it.
Okay.
I don't know. I know
All
we're
right.
on day 29.
How much longer, and I'm not curbing you in any way, how much longer do you think? It seems like after the very lengthy qualifications, we're now moving along quicker with Dr. Laposada.
I would guess I probably am going to finish under an hour.
Okay.
In under an
Any
hour.
idea, Mr. Brennan?
Nope.
I guess it'll probably be about a half hour.
Okay. So we should finish with Dr. Laposada's testimony either by the morning break or shortly thereafter. So we'll discuss Dr. Rentschler's testimony, the objections to it. Why don't you just tell me briefly, Mr. Brennan, what the objections are?
There are a number of slides that attempt to frame what the contested issues are in the case. It's improper opinions, it assumes facts, not evidence, and improperly summarizes the commonwealth position. There are a number of slides that provide credibility determinations about Dr. Welcher, and there are a number of slides that summarize opinions by this expert. So the improper summaries, the credibility determinations, trying to frame issues for the jury, none of that should be admissible as part of the PowerPoint. So we've articulated each slide and what our objections are. Each slide that we have any objections to, there's quite a few.
All right, so I'll look through that tonight, but the same restrictions will be, you don't criticize the person, it's the data, what you saw, what you didn't see. So if it's different than that in the slides, it's going to have to come out.
Understood. I'll take a closer look at it. I just haven't had a chance.
Yeah, no, I understand. I haven't read it either.
If we're done.
Okay.
4 documents. These are documents that are intended to Dr. Lapasada's opinion and conclusions concerning the dog bites.
Okay, so
I'd like to have those identified for the record.
I agree
Yes.
on the 8:30 stuff,
So we'll make
guys.
that part of the record.
They're there at
I need a clean copy of Dr. Lapasada's report and her resume for the same purpose.
And the resume.
Yes.
Yes. I'll have those 2 by the way.
Okay.
And just finally, the redacted version of the 34 Fairview post is not marked. Could I have that marked as an exhibit now?
Okay. There was no objection, Mr. Brennan?
This was never marked as an exhibit. That's all.
What? Why don't we do that right now?
Yeah, Bev, maybe if you had done some of this stuff before, we wouldn't have sat and sat and sat
24.
for ridiculous things all day. Like, come on.
So I would like us to be as efficient for these jurors
I agree, Sarah Lynn. Well, maybe
as
judge can only be stayed
possible
after 4
tomorrow.
every day.
I'm not suggesting that today was a waste of time. Everything we
It
did was
was.
important, but it's very difficult for the jurors to spend so much time back there. It seems that they're just about ready to get this case, and everything that we hear now is very important. So I don't think
They're
anybody
ready.
wants the jurors to tune out at this point. So let's try and keep things moving along. Mr. Jackson, how
Right.
long do you expect to
efficient
be with
process.
Dr. Rentschler?
Hour and a half. 2 hours.
2 hours.
I'm being corrected. 3 hours.
3, 4.
She has a better pace than I do. I don't watch my watch when I'm directing, but maybe it's gonna be a whole thing. I mean, between us. and
Could be all day.
cross-examination.
All right. So I told you all the other day, I thought I might be in a position to regret giving you last Thursday off. And that's where
You
we're at.
think?
So let's be as efficient as we can possibly be.
That's on you, Your Honor.
I understand. All right.
That's on you, ma'am.
Okay. So, Mr. Jackson, do you expect that Dr. Rentschler will be the last witness that you call?
That's my expectation.
Okay. On
What did he
rebuttal,
say?
any idea how long that will be, Mr. Brennan?
I'd like to keep it to 2 hours.
Okay. All right, that would be for everything, including Dr. Wrench,
I'm sorry,
Dr. Welcher?
Dr. Welcher, and then the DNA, all those witnesses. I think it should be done in less than an hour.
All right, so will Dr. Welcher be called after the DNA people?
Trying to schedule that. I expect to call him last, but it all depends on when we can get the DNA people, and Dr. Welcher will be here tomorrow or tonight, so he'll be here. So whoever's, if they're available, I'd like to get the DNA people first. But we haven't had confirmation on this.
4 hours.
All right, because I told Mr. Lessie that he could excuse himself from this testimony if there were other witnesses first, so that he can prepare once he gets the discovery from Dr. Welcher.
wow.
Thank you, Your Honor. Could we understand from the Commonwealth the names of the rebuttal witnesses we're talking about?
They were in the motion, right?
Well, we heard some different things at some point. That if something happened with Dr. Lapasada, they were going to be different. We heard that at Sidebar.
Okay, so the motion that I allowed was Ms. Kuhn, I believe Dr. Gillespie's name was in there
Hartnett.
and Ms. Hartnett. Okay.
So that's it says it's the scope of Dr. Welcher or the scope of the rebuttal witnesses for the county.
Yes, I allowed the motion. Mr. Brennan says he's not calling Dr. Gillespie. Mr. Gillespie, right? Okay.
And nor Dr. Crosby.
Or Dr. Crosby. Right.
That's what I think there's.
Sorry, I know.
Well, it's important to know.
You're not calling their dog expert or your own, correct?
Not calling Dr. Crosby.
Okay.
The other item, Your Honor, we want to alert you to, we will come tomorrow with a suggestion with regard to the curative instruction that was given to the court today. We're going to come tomorrow with an ask to be heard on that. So we're going to come in with that. What happened, what was discussed before, I'm not so sure.
You asked me to change it, was my recollection, Mr. Alessi.
We looked at it at lunch, Your Honor, and appreciate the opportunity to confer with you on that. Didn't want to keep the staff waiting today.
And I don't want to keep the jury waiting, so file something with me and I'll take a look at it. All right.
Yeah.
All right, so that's it. We expect to be ready to go when the jury's here tomorrow morning, probably no later than 9:15, 9:20, right?
Yes.
Okay, and we'll use a full day, as much of it as we can.
Oh, yeah.
Yes?
Yes, Your Honor.
Okay, all right, thank you.
All right.
The gloves was because the shirt. The sweatshirt. That was the thing. The sweatshirt. So we had to put the gloves on to hold the sweatshirt. It was just so obnoxiously silly. Like, yeah, and then you want to cry about, oh, I shouldn't have given you last Thursday off. Well, that's on you, Your Honor. You want to leave right at 3:58. You want to make these breaks that are supposed to be 20 minutes, 40 minutes, a lunch that's supposed to be 40 minutes, an hour and 20 minutes. Who is she blaming other than herself about timing? Now, all of a sudden, you want to get this case over with? Well, so does everybody else on planet Earth. Did you think about that before you were giving these half days and days off and letting the defendant herself take a sick day when she clearly was not sick? They were definitely theatrics, come on. Yeah, for the weather, it being too hot. You have an air conditioner, you have fans, like, come on. They were stupid. You don't put them on until right before you're going to hold something. So, come on, seriously. And that's another thing. You touched everything else in the freaking room before you touched the thing. Like, cross-contamination much? Just saying, if this case did need to be done again and anything needed to be done with that sweatshirt, that's a bust. Other than DNA. Right? They just magically sanitize. Beep, beep, beep. You give jazz hands and they magically sanitize. Like, come on. These on-the-fly motions, she should have already been knowing what... You should be able to read a motion as a judge, hear the arguments, and decide right there. It shouldn't have to be looked over for 7 hours or 7 years. And here's an idea. And maybe if you looked at them after 4:00 p.m., instead of just taking your stuff and going home, then some of this stuff could be decided in the morning, or you should be there at 8:30 in the morning doing this stuff. It was exhausting. I'm exhausted. Oh, the pounding of the podium, like the screaming, the yelling, that it's so obnoxious. Yeah, nobody's ahead of schedule. The fact she even says that, like the last trial was 9 weeks. Okay. There was far less witnesses in this time around. There's no reason why it should have taken as long as it did. We could have already been done with this. It's just crazy to me. Way too many sidebars. You're doing at least 7 to 10 sidebars a day. Like what? I've never seen anything like that. 7 to 10 sidebars a day. That's crazy. That's absolutely crazy. So the update on the sewer turtle stuff is they talked to the lady that took the video. They talked to a court officer. They did about 2 hours and then they ended it and they have to go back Wednesday. So there really isn't much on that right now other than what I just told you. I'll give you a better update in the morning. That's the best I can give right this minute on that. Ridiculous, in my opinion. The bottom line is he did violate the order. He was within 100 feet. It's really just that simple. I don't know why they need to have a 2-day circus to prove that. I don't usually see this in violation cases. Usually it's pretty cut and dry whether they violated it or not. He asked for a bench trial, which is, you know what? He deserves a bench trial. The judge still has to follow the law. He would have gambled better with a jury than you would a bench trial, in my opinion. But hey, yeah, the defendant went and got her hair done. We are on week 8, I think it is, right? If you count like all the days that they took off or whatever. And I mean, we had a lot of those last trial, and it was 9 weeks, I believe. I remember because I covered the whole thing, and it was exhausting, just like this is exhausting. Make no mistake about it. Yeah, you know what I'm saying? Trying the case by sidebar is just so absurd. I've never seen so many sidebars in my life, ever. And this is not a Massachusetts thing. Let me make that clear. This is a Beverly Cannoni thing. Okay. This is a Beverly Cannoni thing. This is a judge thing. If the judge thinks that the jury is getting antsy, or they don't want to sit still, or, they want it over with. Well, you know what? You should have thought about that. Really. That's on the judge. You're, not taking up time, like, using the morning breaks and lunch if you have to get shit done. You're doing that, but then also giving another half hour, another 20 minutes on a break. Then get there at 8:30. Then go after 4. There's no law that says you have to stop right at 4 or start after 9. She never starts right at 9 either. It is a ridiculous amount of time for such a simple thing, and she's not ahead of schedule. That's the reality is she's not ahead of schedule on this trial. She's just not. So for her to keep telling them, we're on schedule, we're ahead of schedule, they're not on schedule. It's like a form of torture at this point, in my opinion, at least. It's a form of torture. We have to listen to a Lessie screaming a yelly, for a half an hour over nonsensical nonsense, screaming about mistrials every 2 days, because that's all they have right now is the hope of a mistrial. Hope of a mistrial. That's how weak the defense's case is, and they know it's getting hammered. So all they can hope for is a mistrial. That's sad. Oh, God, I'm covering that one too, the Idaho 4, and I know that one's going to be long, but at least I'm prepared for that to be long and more fluid, if that makes sense, Yeah, it's like, this is not a capital punishment case, and those take a long time. Yeah, I mean, it should not have taken as long as it has at all. That's for sure. That's another thing. Rule on these damn motions. If there's a motion the night before, you should be ready to rule on it in the morning. If it's made in the morning, you should be ready. You should be looking at it at lunch or the morning break. Like, come on, let's get this stuff together. All right. I've never seen so many voir dires either. Usually, again, doesn't happen like that, folks. All right. We'll be back 8:30 in the morning tomorrow. You guys know the time, you know the place. We're here at 8:30. So do me a favor on your way out. Okay. Hit the like button, hit the subscribe button. If you can donate to the channel, we do appreciate it. We are a small channel, and we are still, trying to climb. I had that 6-month break with my daughter's health. And so we're still, trying to grow this community. We've been covering this case since 2023. It's been a long road, and we've had the breaks because of health and whatnot. So, we keep pushing along, but we need your help to do so. The like button, the subscribing, that's all free. You don't have to pay for that. To share the video, that's also free. It also helps the channel. All those things help. Writing comments on them after it isn't live anymore, that also helps. But if you can donate to the channel, that's always helpful. We have things like Venmo, Cash App, PayPal. We have a link for those of you who don't have any of the payment apps and just want to use it credit or debit. I don't read anybody's real name. That stuff stays anonymous because there are crazy people in this world. Just if you donate when I'm not live anymore, as most of you know, I read it on the next one. So that'd be in the morning. If I get them tonight, they'll be read in the morning, minus the names, because we don't read people's, regular names. I hope I do too. I have to check. I haven't been outside to check yet. So hopefully we'll have some sound tomorrow where I can use the headphones and sound so that I can use the other tech. We don't have to keep using the slow buffery laptop. Although we didn't buffer today. That was a good thing. We didn't buffer today. All right. I love your stinking faces. I'll see most of you in Discord probably in a little bit. I'm going to go eat something. I love you, and I'll see you at 8:30 in the morning tomorrow morning. Bye.